Hello, good morning, sir.
Good morning, madam.
Sir, am I audible?
Yeah,
Sir, first I would like you to, pin the PPT.
you are.
First, I would like that you should pin the PPT.
PPT.
Yes, kindly pin the PPT first.
No, PPT I will show on my when I will give my presentation.
Okay, okay. Should we start then?
Yeah.
Okay.
How many
Good morning,
participants?
everyone. This they'll keep on joining. Good morning, everyone. Welcome to the second day of the short-term course entitled Intellectual Property Rights. Our expert for today is Dr. Rajendra Kumar. He is professor in the Department of Humanities and Social Sciences at NIT Kurukshetra. Besides having various international publications and books to his credit, Sir was conferred the status of Research Fellow by the American Biographical Institute USA 1994. He is the life member of Indian Economic Association, Haryana Economic Association, annual member of IABE USA. Sir has been granted two research projects on IPR by MHRD. Apart from academics, Sir has made significant administrative contributions as well. He was the first public information officer of NIT Kurukshetra, controller of examination from 2008 to 11, HOD of the Department of Business Administration from 2013 and to 15. With these words, I welcome you, sir, to our second day of the short-term course.
Well, thank you, Sadhika. How many participants you are having for this course?
94 for the time being, and they'll keep on joining.
Okay. So should I start my presentation?
Yes, sir.
Okay. Well, dear participants, I'm thankful to Dr. Sadhika that she has introduced me. Presently, I'm in the management department, not in the humanities and social sciences department, but anyhow, that will make no difference. And I have selected the topic for you. In fact, that I was supposed to deliver my lecture yesterday, but due to some my busy schedule, I couldn't make it. And today I'm delivering my lecture. And I will discuss this IPR because most of you may not be having the idea about intellectual property rights. In fact, that why these IPR laws have become very popular in our country and all over the world. If we see little historical facts, in the end of the last century and beginning of this century, so many changes took place all over the world. And one of the significant change was introduction of WTO, World Trade Organization. World Trade Organization started its functioning since 1st January 1995. And what was happened that WTO introduced two more clauses besides the compulsory clause, trade in goods. Trade in goods in the first clause that the goods of the agriculture sector were also included, and two more clauses. One was general agreement on trade in services. 13 services were identified, and education was one of them. Then third clause was compulsory clause, TRIPS, trade related intellectual property rights. So the moment TRIPS was added as a compulsory clause in the new regime of the WTO, then IPR laws became very popular not only in our country but all over the world. So that is why that we are having this course for you, and most importantly that today I will discuss the conceptual side, that what is the concept of the IPR, what are the forms of the IPR, and how these laws will affect your career, that your day-to-day activity. If you are a researcher, if you are doing your PhD, if you are guiding PhD, if you are in publication, that these laws will help you a lot, will assist you a lot. So today that I now start my lecture. So if you go by the title Intellectual Property Rights, Concept, Forms and Relevance, so through this lecture that you will come to know about the concept of the intellectual property rights, various forms of the intellectual property rights, and what is the relevance of IPR. So the point here is that when we see the meaning of the intellectual property rights, then you will find three words basically. Intellectual property rights. What is the meaning of the intellectual? Relating to human intellect. The intellectual level of an individual is different from the other. It is a fact also that all we people are having specializations in the different areas. Our intellectual level is different in comparison of other. So intellectual that relates to human mind. When we talk about property, something that one owns or possesses. For example, you are having a plot, this piece of the land, you may be having a building in your name, you may be having a car in your name, you may be having say the bike in your name. So these are the examples of the physical property. But there is some different type of the property also, that suppose if you have written a book in your name, this will become your property. If you have filed a patent, if the patent is granted in your name, that will also become your property. So it means that the different type of the property that this is the product of the human mind. And most importantly, as we are dealing the physical properties, we are dealing nowadays the intellectual property also, the product of the human mind, and that will be treated as the property. See, patent, when you talk the book, when you talk about the novel, when you talk about the poems, that will become the property of an individual. Rights, a legal claim. Legal claim means, say for example, if you are having a piece of land in your name, if somebody will try to disturb your right, then immediately you can call a police. You can file a complaint in court also, police also. Then police will protect your claims, will protect your rights. Similarly, if you are having patent in your name and somebody will try to use your patent without getting your permission, that you may go in the court, you may complain to a police, then police will take legal action as per the law of the land. So it means that this is a legal right. So what is the intellectual property rights? Intellectual property rights, a legal claim granted to the products of the mind, that is rights granted for inventions and innovations. So if you are very fertile mind, if you are having patents in your name, if you have written the books, if you have the different type of the property and your property, intellectual property, that will get the legal protection through the IPR laws. So in fact, that IPR laws, all are having the legal entities. In fact, these are the legal rights basically. So through the IPR laws, that we will see the various laws. Legal side, whatever the laws have been passed in USA may be different, laws in other countries may be different. IP can be, it may be licensed. Licensed means, say for example, patent is commercialized, developed the technology, and people are asking your technology, then what can you do? You can give the license to the users. You can say that, okay, they are the 4 users, 5 users, 6 users, that you can issue them the license. License means it is a legal permission. You are giving legal permission to the users. Then sold means that you may say, okay, that I am not issuing the license. If you like my intellectual property, my patent, my the technology developed by me, that you can purchase it. And lump sum you can say that, okay, you pay this amount to me and I will transfer my rights to you in your name. Gifted means that to your near dear, that without charging anything, you can gift also, because this is your property. You can gift your children, you can gift your near dear, that because this is your property. Inherited means that if you see the law of inheritance in our country, particularly the joint Hindu family, that you will find that the property of the father that will be equally distributed among the children. So it means that if you are having a book in your name and the benefit you are getting from writing the book in the form of the royalty, then you can transfer your rights to your children also. These rights automatically will be transferred to your children. So now I think that the concept is clear to you. What is the intellectual property rights? What is the meaning of the intellectual property rights, and how these rights will be used as per the law of the land. So another important side is that these laws will differ country to country. So these are the territorial rights basically, that if you wish to apply these rights outside the country, then the laws of the concerned country will be followed. So whatever the laws I will tell you from the point of view of our country, not the point of view from the other countries. When you see the forms of IPR, so these are the 7 forms of the IPRs: copyright, patent, trademark, industrial design, geographical indications, trade secret, layout designs of integrated circuits. I am sure that most of you are the academicians, those who are attending this course. So that is why that I have taken the copyright. And if you are students, that if you are professors, teachers, if you are research scholars, if you are MTech students, then you will be benefited by the knowledge of this law. And if you will not follow this law, that you will find so many problems also, so many troubles also in your career. So I start the copyright. So what is the copyright? You just see the meaning. Copyright and artistic work. So it means that under the copyright, only 2 types of work of a person are covered. One is the literary work and another is the artistic work. So artistic works and literary work, that will be covered under the copyright. So legal protection will be given to both types of the work, literary and artistic works of a person under the copyright law. Ask me the question about the definition of the literary works and the artistic works. You go through this. Literary works such as novels, poems, plays, reference works, newspapers, computer programs, databases, films, musical compositions, and choreography. These are the examples of the literary work for the copyright law. As I have told you that these are the laws. These are having the legal entities. It means that the work of a person, literary work of a person, like novels, poems, plays, reference works, newspapers, computer programs, databases, films, musical compositions, and choreography, that will be covered under the literary work of a person. If you see artistic works such as paintings, drawings, photographs, sculpture, architecture, advertisements, and technical drawings. So these works will be covered under the copyright law, the head of the artistic work. So you are very clear about the literary works and the artistic work. So you can put your work as per the copyright law. Cinematographic films, which includes soundtrack and video films, that will also cover under the copyright law in our country. Record any disc, tape, perforated roll or other device will also be covered under the copyright law. So as per the copyright law, Indian Copyright Law Act, these works of a person will be considered, will be protected, will get the legal sanctity under this law. Now there are some other rights also, say related rights, that will be covered under the related rights. Say performing artists such as actor and musicians in their performances. So the work of these persons will be covered under the copyright law, but that will be covered under the related rights. What is the meaning of the performing artist? It means that, say for example, when a teacher will engage a class physically, that he is a performer, she is a performer. This is a performer basically. When a person will do complaint against Shah Rukh Khan that he has copied me. Then immediately the attorney of Shah Rukh Khan advised him, sir, filed unconditional apology, otherwise you will be of the thing. So it means that the performance artists, if some will try to copy them, that they stop the other person. That similarly musicians also, if they will copy recordings and compact disc in their recordings, that will be covered under the related rights. And broadcasting organs, the TV channels, that will be covered under the radio and TV programs copyright law, but that will covered under the related rights. So it means that if you talk about this law, that whole film industry, whole music industry will be covered under the copyright law. So this is very serious law, and the scope is very wide. Rather, the scope of the copyright is more than the patent law, because I will discuss the patent law also, but you concentrate on the copyright because most of you will be affected by the copyright law. Why protect copyright? Very big question that you will ask me, sir, why this law was introduced and what is the need of this law? In fact, that as I have told you in the beginning, that we people are having the different type of the mindset, mind level. Some of us may be very good in singing, some of us may be very good in writing the books, novel and all that side. So these are the different type of the characteristics of the different persons. So when a person will invest the time, will invest the knowledge, will invest the money also. So, and the whole society, the people will be benefited in general. So such type the people must get the recognition and must get the financial benefits, because when we talk about the benefits, that they must be compensated in form of the money. So it means that the other people, they will not copy the work of the others. In ancient time, that those who were the intelligent persons, particularly those who were, say, the very good in literary works, that they were very poor also. For example, Munshi Premchand in Hindi, that the novelist, and he wrote very good stories also, but he was a very poor person. If you find today that in our country, you will find more than 1,000 people, those who have completed their PhDs in Hindi on the work of Munshi Premchand. Another example, if you see Shakespeare, Shakespeare was also a very poor person, and he was very rich academically. He has written novels also, drama also. If I repeat, that you find more. So it means that such type of unauthorized work should be stopped, and the people, those who have developed originally, those who have written originally, they must be benefited and they must be compensated in terms of the was done in 1983, then 84, 92, 94, 99, and finally in 2012. This is the address of the copyright. Now all the laws have come under one umbrella, and this is the Deputy Registrar of Copyrights, Copyright Division, Department of Supermarket, Agast Kranti Bhavan, Bikaji Common Palace, New Delhi. So this is the address of the Deputy Registrar of the Copyrights. Earlier it was under the and all the laws have come under one umbrella. this copyright law in such a manner so that you participants easily can catch the idea that what are the things will be covered under the copyright law. So you persons may ask me, sir, you are having so many ideas, and can your idea be protected under copyright? No, never. Idea will never be copyrighted, or ideas will never be copyrighted unless you convert the idea or ideas in the material form, in the form of a book, in the form of a novel, in the form of a patent. Then this will be protected under the IPR laws. But idea and ideas will never be protected. According to a survey, a common person in a minute may get 20 new ideas. So you can count also. So it means that a person will get the 20 new ideas. So how the ideas may be protected under the copyright law or under the patent law. So idea or ideas will never be copyrighted or patented. What is the term of copyright protection in India? So for example, you have written a book. So for how much time you must get the benefit? You are the author of a book. Then throughout the life of the author plus 60 years, the benefit will be given to the author throughout the life plus 60 years. It means that after the death of the author, these benefits will be enjoyed by the family members of the author. That is why Gandhi and Nehru family, they are having lot of income only by the work produced by Mahatma Gandhi and Nehru. They are getting the royalty of this work. Very recently, this Rabindra Bharati University approached the authority, Indian government, tried to enhance this limit after the death of the 60 years, because they mentioned that university is getting huge royalty on the work of Guru Rabindranath Tagore under this head. So they wanted enhancement in this select period so that they may be benefited. And in case of the photographs, posthumous publications, anonymous, pseudonymous publications, works of government and international organizations, the term of protection is 60 years, and that will be counted from the date of publication. In case of the broadcasting, the TV channels, the TV programs, the life is 25 years. So, you can see it means that if you will do something in the different manner, in the form of a book, in the form of a novel, in the form of the story, that the benefit a person may enjoy throughout the life plus 60 years. So as I have told you in the beginning, inheritance means that these benefits will be transferred to the children of the author automatically as per the law of inheritance in our country. What are the rights of a copyright holder in the case of literary, dramatic or musical work? In fact, that you participants may not be interested in this, because these are the different kind of the work that you may not produce a movie, you may not produce a drama or this musical work. So I am deliberately eliminating this so that I can discuss all the related things with you in detail. Can any person translate a work without the permission of the owner of the copyright in the work? No. Listen carefully this side, that if you wish to translate the work of a person from Hindi to English, English to Hindi, Hindi to Urdu, no, it is not permissible as per the law. For this job, you must get the permission from the original author. Is there any copyright over news? No. The aim of the news is to disseminate the information among the people. But the way, the method, the person will present the news, that will be protected under the copyright law. For example, Rajat Sharma has his own style. Other persons, they are having their own style. So their styles will be protected under the related rights, the right of the performer. Because when a news reader will present the news, that the style of the person will be protected under the copyright law. But there is no restriction on the news, because the aim is to disseminate the news among the people. What is understood by copyright industries? You know that nobody thought in earlier stages that one day that the industries will be covered under the copyright law, but we are having so many industries like book industry, music industry, film and television industry, computer industry, database industries. All these industries will be covered under the copyright law nowadays. So this is very important law. Computer programs, yes. Indian Copyright Act amended in 1984 accommodated the rights in a computer programs as a literary work. How is computer defined for the purpose of copyright? Computer includes any electronics or similar device having information processing capabilities. This is the definition of the computer as per the Indian copyright law. What is the definition of a computer program? Computer program means a set of instructions expressed in words, codes, schemes, or any other form, including a machine-readable medium capable of causing a computer to perform a particular task or achieve a particular result. So this is the definition of the computer program. Can software be protected through copyrights? You just please, because some of you may be having specialists in these areas. So as per the amended law, this patent and copyright, presently software is protected under both the laws. The difference that is very simple, that you are using your laptop, you are using your computer. If the software is inbuilt with the hardware, that will be covered under the patent law. If software is uploaded separately, that will come under the copyright law. Say, for example, when you operate your computer, your laptop, then when you use the software, you will find the copyright. So it means that the software is uploaded separately. But if it is inbuilt with the hardware, that will be covered under the patent law. So this is the difference, but majority of the softwares are covered under the copyright law. Can copyright be a useful form of protection in biotechnological inventions? Yes, where huge data base is required, that will be covered under the biotechnology, under the copyright, but most of the researches of the biotechnology will be covered under the patent law. But where huge database, because database industry will cover under the copyright, so that will be covered under the copyright law. If an employee in a company develops a program, would this employee own the copyright? No, unless the employee is having some contact with the employer. Even if you write a book in your institute, in your suppose you are employee of NIT Jalandhar, if you write a book, if you see the rules and regulations, that the right will go in the name of the institute, not in the name of the individual. So nowadays most of the institutes are having the IPR policy. Say for example, NIT Kurukshetra is having the IPR policy, because I am working as the coordinator of IPR cell also. So we are having all the rules and regulations clear. So presently in our institute, if somebody will file a patent, that will go in the name of the institute, not in the name of the individual. Individual will be the innovator, and the patent will go in the name of the institute, and the whole cost of the patent will be paid by the institute, not by the individual. So it means that unless the employer or employee, they are having some different type of the understanding, that they have the different rules, but as per the rules, that will be go in the name of the employer, not in the name of the employee. What is the rule for the transfer of copyright? You know that it is your property. That it means that within the country, you can say that, okay, in this part of the country, I am giving free. In this part, I am giving on payment basis. So it is a purely on the wish and will of the individual, of the copyright holder. We do not have the specific rules and regulations, that will depend on the individual will and wish. How much of someone else's work can I use without getting permission? Very, very important. We do not have the uniform rules in our country also. That differs institute to institute. UGC has clearly given the guidelines to the institutes, to the institutes, that you must follow these rules. Say 5 words in continuation, 6 words in continuation, 10 words in continuations. Then, and most importantly, whether you give 1 line, 2 lines, 3 lines, you must give the code, and don't forget to give the name of the original author, the complete reference of the original author. Then you will find yourself safe, otherwise you will be in trouble. So don't try to copy others. Give your original work, and in addition, that if you wish to quote the work of others, that you must give the proper quote to remain safe in the academic world. Is a television format protected by copyright? Yes, that will come under the related rights. Is a character protected by copyright? Very, very important that you know that this law so serious, that this law protects even the characters. When you will write a novel, when you write a drama, as an author, the person will develop some characters. So these characters will also be protected under the copyright law. For example, if you say in Sole movie, Basanti, Gabbar Singh, Biru, so these are the characters developed by Salim Javed. So Salim Javed still have the rights on these characters. The movie was produced, so that after a few years, that one person, Ram Gopal Verma, tried to copy this movie, that Salim Javed, and they immediately stopped the person. They said, no, you cannot do like that. These are our property. These characters are our property. And not only the characters, even the dresses of the characters are also protected under the copyright law. Most of you have seen the movie Binti and Bubbly. This was produced in 2006. Rani Mukherjee was the heroine of this movie. That the case was related with the dress of the Rani Mukherjee. The dress was prepared by, there were the two persons, costume designer and dress designer. Dress designer prepared a dress for the heroine of the movie. Then costume designer immediately objected and said, sir, this is my design, and this person has stolen my design. That the person said, no, I have purchased it from the footpath market of Bombay. Then there was a dispute, and both the persons went in the court. The decision is still pending. But what I wish to impress you persons, that this is so serious law that even the dresses of the characters will also be protected under the copyright law. See, deliberately that I have introduced this for you, because being the academics, you must be clarified, because when you submit a research paper nowadays in any journal within the country, outside the country, then you will find plagiarism report. If you not submit your plagiarism report, then your paper will be returned in original to you. So go by the definition: wrongful appropriation and stealing and publication of another author's language. See, there are only 4 words: language, thoughts, ideas, or expressions. So these are so wide. It means that you cannot steal the language of others, thoughts of others, and ideas of others. And expressions, very, very important, the whole film industry, that will come under this side. So this is the definition of the plagiarism in very simple way. So be careful, go by this definition. Another interpretation, close imitation, the representation of them as one's own original work. It means that if you closely imitate the work of others, that will be the part and parcel of the plagiarism, and it is so serious that once you come under this trap, that you will face so many problems in your academic career. So avoid such type of things. This is very, very important. So nowadays that you will find, even if you write a book, if you write a say the article, if you write a research paper, anything if you write and it will be published, then be careful. You should not steal the work of others and give this work in the publication, in the book, in the form of the publication, that you will find yourself in trouble. Which are the common copyright infringements? You know that here the important point is that you know that you like an article and you ask the person, you photo state it, and say no, sir. 1 or 2 pages if you ask, that we can do that, but we will not do this. In fact, the whole thing is that if you will use the work of others for the academic purposes, for your academic purposes, there is no restriction, nobody will prevent you, nothing is wrong with this side. Because I am covering all this very quickly, because I have to cover a lot of things, and I do hope that you will be benefited. But here I am telling you very categorically that, say for example, for your research purpose, for your teaching purposes, you are having the work of others and you are using for teaching purposes. Nothing is wrong, you can do that. But the problem will be when you commercialize the work of others. What is the meaning of the commercialization? So for example, you want a book written by foreign author and published by the foreign publisher. When you see in the market, the price of the book may be 5,000, maybe more than this also, because the foreign publishers' book are costly. Then you are not in a position to pay 5,000 rupees. Then your mind will work that, okay, what you can do, that you can get a book from the library and you can photostate the whole book. Suppose there are 150 pages. Okay, you can do that. Nothing is wrong. Because you are using this book for your academic purposes. But further your mind may work, because human mind is very fertile. As I have told you, you will get so many ideas. Further your mind may work that okay, if I can do, the price is 5,000 rupees. If I get the colored photocopy of this book, maximum 5 rupees per page I will spend. And if I bind it, it may cost say the hardly 500 rupees per copy, and if I sell it 1,000 rupees per copy, that I will get 100% profit. Then such type of activities are strictly prohibited in this area, because loss will go to the original author and loss will go to the publisher also. So if you are engaged in such type of activities, then you will get the punishment, and punishment is very severe in these areas nowadays. So here the point is that if you are using the work of others for your academic purposes, for example, review of literature and all that, nothing is wrong. You go freely, consult so many books freely, articles freely. But if you will try to commercialize this work under your name, that is highly, strictly profitable. If you will not, then you will find the punishment. Is copyright infringement? Yes. Any person who knowingly infringes or abets the infringement of copyright, that will be covered under Section 63 of the Copyright Act. And the punishment, if you find this punishment, this is nothing, 50,000 rupees fine or 6 month imprisonment. Second time it will become double. So it is nothing. It is very simple. But here that that few case history, 1 or 2 case history I will discuss with you due to the shortage of the time. But anyhow, that you will agree with me that okay, if there is a financial loss, it may be recovered. But through the case history, the type of the punishment you will find, that is very serious. So, you are aware about Chetan Bhagat, you have heard the name, and he became popular by the movie of the Three Idiots. Amir Khan produced the movie, and when the movie was released, Chetan Bhagat immediately objected and said, "Sir, this is based on my novel." Then he was IITian when he did his BTech from IIT. Then he wrote the novel and he said, "Sir, these characters that I produced, all these characters." Then Amir Khan said, "No problem. Whatever you are saying, you are 100% right. Now you just ask the money. I am ready to pay you. I have produced the movie. So the only thing that if you want money from my side, you get it." And he got the money, and then he said, "Okay, if you are having better than these novels, that you give me these novels, I will make more movies." And slowly he has become the established author. But now the case is against him also. The copyright, that one lady that she gave short stories to him for the comments, and what he did, that he developed one story. And now lady is saying, "Sir, I submitted the collection of my stories to the story, and he developed it under his name." So this case is still in the court, but he has got a bad name. Do you sex reader or fake research? This case history, that because I am discussing all this very quickly. Here the point is that there was one person, Yogesh Mathur, he was in the university, and what he did, that he published the work of others under his name, and he applied for the post of professor. Instead of giving promotion, that his services were dismissed by the Delhi University. This was the case in very nutshell. Ex-Vice Chancellor of Delhi University sent to jail for plagiarism. He was the Vice Chancellor, Deepak Pental. Most of you may be knowing the name. That his mistake was that after completing his term, when he back doing the department, the university, he was having some project in collaboration with others. He in the biotechnology department. So he published a research paper that in this area. Then he mobilized him. Then the person complained against the Deepak Pental. It was approved, and he was behind the bars. So this is so important. Why I am telling you again and again, don't go in such type of things, in such type of disputes, otherwise your academic career will be spoiled. This is a very important message that I wish to convey to you. That if you see that this is not a national phenomenon, it is the international phenomenon. And in Chinese university, there was the problem. 3 faculty members were terminated from their employment for faced disciplinary action, including a pay cut, and the rest were issued with public or internal warning. And some have been temporarily forbidden from taking PhD students. And the decision the university took because they were also involved in the plagiarism case. So avoid such type of activities. So if you recognize these 3 faces, very important persons, it is the Putin is still in the power, president of Russia. Biden is trying to become the president of USA. He is contesting the election. Then he is the former Barack Obama, the president of USA. So these persons were also involved in such type of activities earlier. And these are the guidelines issued by the UGC. So I'm not discussing these deliberately because I'm having a shortage of time. So that's all about the copyright law, and I do hope that you have got the idea why you should avoid the plagiarism and you should not steal the work of others and try to get published from your name. So this is something different. Now the second law, this is the patent law. So here quickly I will discuss this law. These are the various forms of the IPR. Normally that if you do not all the form that you will confuse that patent means IPR, IPR means patent. No, there are the 7 types of the IPRs. So copyright is one of them and patent is another. So what is a patent? Because most of you may be having this background because NIT Jalandhar is organizing this course. So you must be having some science background, then some technology background also. So you may be more interested to know about the patent. So under the copyright, all types of the work are covered, but under the patent. In the copyright, that the 2 types of the work were covered, literary and artistic work of a person. But in case of the patent, only the inventions and innovations of a person will be covered. In very simple way, a patent provides property rights to an invention. An invention may be defined. What is the invention? See carefully the definition, otherwise you will be confused. A novel idea which permits in practice the solution of a specific problem. So what is the invention? It is a novel idea which permits in practice the solution of a specific problem. Okay, you are having the idea and this idea will give the solution of a specific problem. For example, I am giving the example, then you will get the idea. Nowadays, the major problem the whole world is facing. This is due to Corona epidemic, this Corona 2019 pandemic. Now, this is the problem. What is the practical solution of this problem? The practical solution of this problem is to give the vaccine, to develop the vaccine that will give the relief to the people. So a person may be having the idea, but is not capable to develop this. But if a person provides the vaccine and make a claim that this vaccine will give the complete cure to this disease, will become the innovator and the work of the person will be patented under the patent law. And you can imagine about the money the person will earn through this research. So it means that invention or innovation of a person, innovative work will be protected under the patent law. Otherwise, if the dispute, a person will develop it. The others will say, sir, I have done this. No. The person who will file first, who will get the patent, then the person will enjoy the lot of benefits. Now, what are the conditions to get the patent? There are 3 conditions. It must be new. If it is not new, then idea will be turned down. Involve an inventive step. It is new, but if the person is using established facts, if the person is using old steps, then the patent will not be granted. Capable of industrial application. It means that this particular research must be applicable. It does not have only the theoretical aspects. No, it must have the practical solution of the problem. If it is not having the practical solution of the problem, then the patent will not be granted. And nowadays, as per the amended law in our country, the both products and processes are patented. Say, for example, products you are aware, say products that you will find so many, a computer, a laptop, a watch, a camera, these are the products. Process to produce a product, there may be so many processes, A process, B process, C process. To produce a medicine, there may be so many processes. Then nowadays, these processes will also be patented as per the Indian law also. The products processes to be excluded from patentability, these are an invention which is frivolous or contrary to well-established natural laws, an invention contrary to law or morality or injurious to public health, plants and animals other than microorganisms. It means that microorganisms will be patented, but plants and animals will never be patented. If we say that neem is ours, brinjal is ours, we are doing the wrong thing. It means that these are the plants, these are the animals. That say, if we say the cow is ours, no. These are the plants, these are the animals, and all the people of the world are having the same right on these plants and the animals. So, but the microorganisms may be patented. If you are making some new variety, then will be covered under the patent law. Otherwise, the plants and animals will not be patented. So, in fact, that here normally I discuss some case studies, but deliberately I am deleting all this due to the shortage of the time. Then, if we say, that our country is an agro-based economy, then in case of the agriculture products, in case of the agriculture side, the plant varieties, that here WTO has given the free hand to the different countries. In fact, that we are having one organization known as the WIPO, World Intellectual Property Organization. All the rules and regulations are decided by the WIPO, not by the WTO. So WIPO is the parallel body, and all the issues related with the IPRs, that will be referred, WTO will refer to the WIPO. So what WIPO did, that WIPO said, sir, no problem, that there are two ways to protect the agriculture researches. One is a sui generis system. Sui generis system is that a country will develop its own system. Okay. Second is UPO Convention on the protection of new varieties of plants. So to protect the new varieties of plants, a convention was held. So here WIPO said that there are the two ways. Either you develop your own system, a country may develop its own system, or country must follow the guidelines given under the UPO Convention. Then we people, Indian government has developed a sui generis system, and a law was passed, the Protection of Plant Varieties and Farmers' Rights Act in 2001. And government said that okay, we will not follow the UPO Convention in this case. We will develop our own system, and we have here developed a law, we have passed a law, we have formulated a law, and through this law we will protect the new plant varieties and farmers' rights in our country. The terms of protection in India is 20 years, and this time will be counted from the date of filing, not from the date of grant. And normally 2 or 3 years or up to 5 years may be taken by the patent office to provide the to grant the patent. And after getting the patent, that it requires renew on year-to-year basis. Suppose you have got a patent today, that after 1 year it will be renewed. If you will not renew it, that will go in the public domain. So this is about the patent, a little bit about the patent. What does a patent document contain? That I have prepared it so that you participants may get some information. Say patent document, say for example bibliography. Suppose you wish to do a research, if you wish to write a research paper, if you wish to write a PhD thesis, then your guide, your supervisor, or if you are guiding the PhD scholar, then you will tell them first that do the review literature, go for the review literature. So bibliography means that you will consult the work done by the others in a particular area you are working. You are filing a patent, then you will see that how many patents have already been filed. So that is why that you will go for the patent searching, you will get all this information. Then description. Under the description that you will give the details, say a prior art, whether people were aware about this technique or not. Current invention, what is the current invention? If some drawings are included, that all these drawings you must give in detail. Claims means that you will discuss the scope of the patent, that in which areas your research will be applicable. You know that in our institute, last 3 years, about 50 patents have been filed, and I'm looking after all these. So from Delhi, and what our faculty is doing, even students are also doing. They are contacting these attorneys. They are providing them all the information, and after completing this application form, they are submitting directly to them, and the application will be filed with the Indian Patent Office. And the information they will send to me, and on behalf of the institute, we make the payment, and they are getting this benefit without paying even a single paisa to the patent office. So this facility is provided by the NIT Kurukshetra. But anyhow, these are the information that if you are planning to file a patent, that you must have all these information with you. When you will file the patent, when you will find the form, that you will be asked to fulfill all these information in the sequence form. Or what does a patent document contain? Then you will find you will see the bibliographic data, abstract of your work, description of invention, prior art information, shortcomings in the prior art. Then you will overcome, when you will give the weaknesses of the earlier work, then it means that you are giving the new work. If you will try to find out the weaknesses of the earlier technologies, then you will give the new technology, and you will say that these the weaknesses that I have covered through my research. Complete details of the invention, drawings and workable examples, and list of claims by the patentee. That all this information you must have with you when you file your patent. Again, in a very simple Hello, am I audible?
Audible,
Yes,
sir.
sir.
You are audible.
Okay. So complete. Okay. So complete specification, that title of invention first, field to which the invention belongs. It may be computer engineering, it may be electronics, it may be biotechnology, or it may be joint also. That if you see the this multidisciplinary research, that but you will find some field. Background of the invention, including prior art, giving drawbacks of the known inventions and practices, complete description of the inventions along with experimental results, drawing, etc., essential for understanding the invention, and finally the claims. So these are the major issues that you must have with you if you are planning to file a patent. Another important side, the suggestion I wish to give you, that if you are planning to file a patent, that I am giving you the patent, the website of the patent office, Indian Patent Office. You can open this website and you will get all the details. But if you will try directly to file the patent, that the information you may not provide in the proper manner, so it is better that you contact some attorney. In the market nowadays, you will find a number of attorneys, and through these attorneys, if you will file the patent, then you will find the positive results. But anyhow, if you are trying to file the patent, you must have the information under the heads. Then the work will be very easy for you. And if you are trying to file a patent, that first you go for the patent search. So through Google, you can do that easily. And in your area, give the area, you put the information that already filed patent in this area, that you will get the list of the already filed patents nationally and internationally. Then you may collect such type of information and you will be able to file your patent. Okay, so this is the little information about this side. These are the नेट चला गया था नहीं, बार पूछना नहीं चल रहा, वो मैंने पूछ लिया मुझे, इट इज वर्किंग. So these are the 4 offices in our country. And because they are the 4 offices, one is in Delhi, another is in this Chennai, then Kolkata, then we have the Bombay. So these are the 4 offices. These are the buildings of these 4 offices. I have given you this because it has a specific purpose. These are the areas that say Mumbai office will handle the people of Maharashtra, Gujarat, Madhya Pradesh, Goa, and Chhattisgarh. The UTs of Daman and Diu and Dadar and Nagar Haveli. Chennai office handles Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, and the UTs of Pondicherry and Lakshadweep. New Delhi, Haryana, Himachal Pradesh, Jammu and Kashmir, Punjab, Rajasthan, Uttar Pradesh, Uttaranchal, New Delhi, and the UTs of Chandigarh, and Kolkata, the rest of the area that I have mentioned in these 3 columns. So I am giving this that if you are planning to file a patent, then you select the area and you contact the patent office as per your area, the area where you belong, that you can file the patent in the concerned patent office. Otherwise, you will waste your time. So these are the 4 offices all over the country. I have given the details of these 4 offices, and these are the areas which are covered by these 4 offices. You know that these are the few case studies. This is a very old story. Apple wins suit against Samsung that Android that they developed this mobile. So you are aware about all these things. This Apple is the US based company. That Samsung, this is the Korean company. So what they did, that they had some dispute related with this technology. Both they approached the court in their respective countries. That finally there was the dispute, that some business leaders told them that both you are doing very well, don't go in this dispute, try to settle all these things, and finally they settled. German company patent for asthma drug revoked. So German company filed the patent in India, but as I told you that you must include the new steps. It was not including the new steps. That is why it was vacated by the Indian government. And Apple company paid $234 million to the person because they used the patented technology of this person. The person was from India. He was from the BITS Pilani, and his MTech student, he was Gurvinder Sohi, and he challenged the decision of the Apple that you have used our technology, and then the court this imposed a penalty on this company. Maybe the India, but I am not discussing this case still in detail. So next is the trademark. So this is the third type of the patent. This is the third form of the IPRs. A trademark is a visual system in the form of a word, a symbol, or a label applied to an article of manufacture or sale with a view to indicating to the consumer the origin of manufacture. It helps to distinguish such goods from similar goods manufactured by others in the same trade. So for example, you have developed a product. How you will differentiate your product from others in the market? I will tell the consumers that my product is different from the other products. It means that you will give some name, you will give some symbol. So this symbol, this name will become the trademark for your product. For example, if we talk, I have given 2 examples, Coca-Cola. This is the special design. This is the special way to write the Coca-Cola. So the Coca-Cola company has already got the trademark on these words. The style, the way, the method they have written. So it is already registered trademarks. If somebody will try to use the Coca-Cola, this trademark, immediately they will give the punishment to the concerned company. The another example I have given you, T symbol, but normally what we are doing, we are pronounced it Tata. It is not Tata. We cannot call it Tata because it is T symbol and T symbol. But it is a trademark of the Tata group of industries. If you find Tata Steel, the trademark. If you find the Tata car, trademark. Tata truck, trademark. So you'll find this trademark, even say the Tata Sab on this trademark. So it shows that this is the product produced by the Tata group of companies. And it is also registered. So this terms of protection of a trademark is 10 years. It means that suppose you get a passport, you will get for the 10 years, but again it will be renewable. So similarly, the trademark will be renewable. And these industries, they are having the lawyers, they are having the attorneys, and on their behalf they are working. So they will not bother about such type of the things, but anyhow, that term of the protection is the 10 years. And after that, a company may try to change the trademark that they will announce, they will say, they will give the advertisement. Now this is the new trademark that this issued by the company like that, and that will be registered again. If it will not be registered, that company may not put the legal claim. So this is the whole story about the trademark. If you see that this is very say the serious law, if the government to fight for Khadi trademark, all you are aware, but it is a controversy. It was a controversy in 2014. What was the controversy? There was a company in Germany, and Germany company was manufacturing the products, and the products were like say the shampoos, soaps, kajal, lipstick, such like the products were producing and were putting the trademark Khadi. So what was happened that the Indian community outside the India, that abroad, that what they did, they preferred to purchase these products. And our government came to know that immediately they put the objection. They said, sir, Khadi is a very popular trademark. During the when we got the freedom, that our freedom fighters used this Khadi as a trademark. This was very popular word at that time. And Khadi was not having any linkage with the freedom. Anyhow, what was happened that time, that Britishers, that if you see the Britain got the this development through this cotton and textile industry. So that time this Britain was supplying the clothes to the all over the world. So what our freedom fighters said, no, there must be setback to the Britain industry, and we should boycott the clothes produced by the Britain. So, and that is why that Mahatma Gandhi said that, okay, now we will use our own product. And he said that whatever the Khadi that he said, but that was very popular. So nowadays what we are seeing, Atmanirbhar Bharat, we are also saying that we should boycott the products of the other countries, particularly China, and we will develop our own products. So this was the idea in fact. But what was happened that this Khadi was very popular that time, and the German company tried to manufacture these products that I just told, the shampoo, kajal, lipstick, soaps, and these were very popular, and there was a high demand, particularly from the Indian community from abroad. So government objected, and this trademark was vacated. And immediately when the trademark was vacated, that Pakistan and Bangladesh, they came forward. They said, sir, our manufacturers will also use this trademark for their products. And they said that, sir, during the freedom struggle, we also participated, because that time there was no Bangladesh, no Pakistan. And then they were right also. And now they are sharing this trademark also. So this was the very popular case study at that time. But here what I mean to say you, that how such the things are affecting the whole business. These are very important aspects, and all are covered under the IPR laws. This is the very small study, Tata Indigo, you are aware about this, related to the trademark. So this Tata Motors, they are having one variant of the this car. This is known as the Indigo, and there is the airline, Indigo airline. So both they went in the court, but anyhow, because court didn't agree by the plea of the Tata Motors, because there must be the product differences. There is the product differences because Tata is not having the airline by the name of the Indigo. They are having one variant, this car. So court said, no, this is the different side, and there is the product differentiation. They are having the airline. If the app logo designer that this Kejriwal that he created, about all this, there was a person Sumilal. What he did that he developed this logo for the party, and now he has left the party. Now he's saying, "Sir, this is my intellectual property, and this party cannot use this logo." Now both are in the court. So why I am telling you all these things, because these are so important issues that immediately you will find the court cases also. So next is the industrial design. This is the fourth part of the IPR, fourth form of the IPR. What is the industrial design? Industrial design protects the aesthetic aspects, shape, texture, pattern, color. Try to understand what is the industrial design. Industrial design, in a very simple way, decides the outer look of the product, the aesthetic aspects of a product. What is the shape of the product? What is the texture of the product? What is the color of the product? That will be covered under the industrial design. So, technical side, no. There is no relation in the technical side. Industrial design, only the outer look of the product. Then you will find a car, say that, for example, Maruti car, Tata car, that within a year, after 2 years, that will find some change in the outer look of the product. That will be known as a new model. Inner side, have they introduced new engine, new technology? No, we are not bothering about that. We are bothering only about the outer look of the product. So it is covered under the Design Act 1911. To qualify for registration, the design must necessarily have certain characteristics. One, it must be an original design. It must not have been published in India prior to the date of registration. So I have given you two examples for your information. These are the two cars of the multinational companies, and the industrial design of both these cars are entirely different. So inner side, the type of the technology these cars are having, we are not bothering about that. There is no relation between the technology used in a car under the industrial design. No, only thing is the outer look of the product that will be developed by the industrial design. So I have discussed these four forms. If you go that how these four forms are used nowadays by the industry people, in the companies to produce the product. If you go, that copyright gives the protection to the literary and artistic work. Patent will provide the protection to the inventions and innovations. Then the trademark provides the protection to the how the product will be differentiated from others. Some name will be given. Some word will be given, and industrial design will decide the outer look of the product. So, that if you find a laptop, then inner side the technology is used, hardware, that will go to the patent law. The type of the software we are uploaded, that will go to the copyright law. What is the name, the title of the product, whether it is Apple, that you will find one symbol of the Apple. Immediately, on the top you will see the Apple, you will immediately it is Apple product, like that. And the outer look of the product, the size of the product, the color of the product, that will go under the industrial design. That how these laws are working nowadays in any industry. Geographical indications. Geographical indications identify a good as originating from a territory, a region, or a locality, where a given quality, reputation, or other characteristic of the good is essentially attributable to its geographical origin. What is the genesis behind this law? That the thing here is that you will find the characteristic of a product, the taste of the product, that may be different from others only due to the geographical regions. For example, if you visit Allahabad, that your friends will say, try to use guava, the amrud of the Allahabad. What you can do, that you can plan that, okay, I will purchase a plant from of guava from Allahabad, and I will come here in Punjab, in Haryana, and I will come along with the plant, and I will grow it. But when you will see the fruits, that will be, you will not find the same taste as in Allahabad. So this taste has developed only due to the geographical regions. So this particular characteristic of the product is covered under the geographical indications under this law. And the quality, reputation, or the characteristic of the good is essentially attributable to its geographical origin. If you see that when we talk about the basmati rice, say if you see in the Nilokheri area in Haryana, the taste is different. In Dehradun, taste is different. Pakistan, taste is different. That is only due to the geographical region. So this characteristic of the product that will be protected under the geographical indications. So I have given the number of examples. Say the most common international examples are champagne and Scotch whisky. Scotch whisky is manufactured in the specific part of UK. This is in Scotland, and this whisky is having the specific taste that the whisky manufactured in India in other places also may not have the same taste. So these are the various examples. Similarly, when we see the Indian examples, we will find the basmati rice, Assam Darjeeling tea, Kanchipuram sari, Kolhapuri chappal, and Kashmiri shawl. So these are the various examples that I have quoted here. And another important characteristic of this law is it is a community right. Community right means that if the manufacturers they want to get the advantage of this law, first they must form a society, and this the right will go in the name of the society, not in the name of an individual manufacturer. For example, if we talk about this Banarsi sari in Banaras, you will find so many weavers, and these weavers are having they are manufacturing the sarees. So it means that if the GI will go to the Banarsi sari, it means that the manufacturers of this area, there will be more than 1,000, all will be benefited by this GI, by this tag. So it means that it will not go to the individual manufacturer. It is a community right, in fact, basically. So that is why it is not very popular in our country. There are the few products that they are going agrega peta. So it means that first manufacturers they will form a society, and then this society will contest to get the tag, this GI tag. And in our country, there is only one office in Chennai. So geographical indications, these issues are decided by the Chennai GI office. Only one office all over the country. Then you have the trade secret or undisclosed information. So when we talk about the trade secret, a trade is having the business only due to the secrecy. When the secrecy will leak, then the trade will over immediately. This is the important issue here, that if the secrecy is leaked, the trade will over. Here I have quoted two examples. Coca-Cola Concentrate. Coca-Cola Concentrate is a multinational soft drink company, and it is having the business all over the world. Now the Coca-Cola is having the specific taste.
वहां से दिक्कत है, बाकी हो रहा है, एक्सेस तो हो रहा है, एक्सेस तो स्टार्ट होगा। हाँ, वो वहां से क्या पता उन्होंने म्यूट कर रखा हो, वीडियो म्यूट करो, तो देखिए मैंने आईडी पासवर्ड वो देख,
Is there any problem? Hello. Should I continue? Should I continue?
Sure sir, please.
Okay. So here I am quoting two examples. One is Coca-Cola Concentrate. Coca-Cola Concentrate, this Coca-Cola soft drink is having the special taste because we are not aware about the concentrate they are using. Company is using the formula to prepare the concentrate. We are not aware about that. If the formula will become common, that the business value of the company will over immediately, because what people will do, people will try to prepare the Coca-Cola soft drink at their homes. And there is a proverb in the Coca-Cola industry that there are only two persons in the whole Coca-Cola company who knows the concentrate, and half one. One person is not knowing the complete concentrate, complete formula of the Coca-Cola concentrate. So this is the proverb we are having in case of the Coca-Cola. Another example is the fish treatment for asthma. That you know that you are aware some of you may be aware, those who belong to southern part of the country, that in Hyderabad there is a family, and this family is providing the treatment to the asthma payment through the fish. Normally, the people may use fish in their homes also, but they do not know the art that how the treatment may be given through the fish to the patient, asthma patient, and the family knows this art. And the moment that this family will leak this secret, the business will be over immediately. So this is the idea behind this trade secret undisclosed information. It means that a business is having the commercial value only due to the secrecy. The moment secrecy will leak, then the business will over immediately. And another question that here you can ask me, that when we talk about the RTI Act in our country, that IPR laws are the exceptions in case of the RTI Act, that if your research comes under these acts, under the IPR laws, then it is exempted from the RTI Act immediately. This IPR laws are the exceptions of the RTI Act in our country. So this is the idea behind the trade secret or undisclosed information. So these are the case studies, but I'm not discussing these case studies. Then the last, this is the layout design of integrated circuits. This is very important. Those who have the, especially in case of the electronics products, that you will find this integrated circuits. Say if I am using this laptop, in the laptop there is one circuit. So this layout designs of the integrated circuits, that will go under the IPR laws. So this was not very popular in our country earlier, but this was introduced in our country in 1989. And that also comes under the DIPP, Department of Industrial Policy and Promotion. Rather, presently all the laws of the IPRs in our country are covered under the DIPP. Listen carefully, DIPP, Department of Industrial Policy and Promotion. So all the laws, including patent law, this copyright law, all the laws are covered under this head, under this department. This is under the control of the Commerce Ministry in our country. So these are the same laws that I have discussed. The last part of my presentation, now I start this. So what's the relevance of IPR? The big question, that why the organizers have conducted this course on intellectual property rights, and what is the use of these laws? Particularly when we see the use, that we always talk in terms of the growth, particularly the economic growth. So nowadays, that a lot of things we are having from our policy maker side. They are saying that, okay, we should go for Atmanirbhar Bharat. Now the question mark is that how will achieve this target of the Atmanirbhar Bharat. So these laws will help in this way to achieve these targets. How these laws will help, why these laws are so relevant for the economy of a country, specifically for India. The progress and well-being of humanity rests on its capacity to invent and innovate. Now the very big question mark, you will agree with me, that why our manufacturers are not so advanced, why they are not competing with the world manufacturers, why they are not competing with the multinational companies. What is the reason? Basically, the simple reason is that the level of the inventions and innovations is not at par with the developed economies. That is why our manufacturers are not capable to face competition with these multinational companies. Now the point is that why government is asking the universities, the IITs, the NITs, that you must produce more and more patents, and your patents must be applicable, must be industry applicable, because industry people, particularly small scale industries, medium scale industries, are not capable to invest money in the R&D, research and development. These are very costly processes. So government may do this job. So government is asking this IIC Bangalore, the IITs, NITs, that you go for more and more patents. You must have your research is result oriented. So what are the patents you are going to file? These patents must be commercial. This is the important point. This is the reason that why government is asking, why government is framing the policy, IPR policy for the country, and why government is asking the institutions, the organizations, that you must pay attention towards the inventions and innovations development. The reason is so that this invention, this innovation will be used by our policymakers, by our business persons, the industry people, and they will compete with the multinational companies. This is the important side, because without the inventions and innovations, our producers are not able to face the global competition. This is one reason. That is why the IPR laws have become very popular. And another important side is that our producers, if they are not able to use new technologies, new inventions, new innovations, so if they wish to use the technologies developed by others, by the developed economies, what is the procedure? That will come under the technology transfers, commercialization of patents. So another issue that you will find, that is handled by the technology the Ministry of the Science and Technology, that how the technology transfers will take place in our country. Technology transfers always will be from developed economies towards the developing economies. So we still have the developing economy. Our economy is not the developed economy. So how the technology transfers will take place, how the inventions and innovations will get the encouragement, how our people, particularly those who are working in the advanced labs, those who are working in the institutions, in the industry also, that they must have the new ideas, and these ideas must be converted to the goods and the services, so that people, the society may be benefited. And another important side is that they must capable to face the competition globally. Individuals and institutions invest time, effort and money in inventions and innovations. Yes, when you talk about the inventions, the institutions also, when you talk about the individuals also, they are investing their time also, effort also, money also in the inventions and innovations. By rewarding inventions and innovations, IPR encourages creativity. So it means that if the persons will be benefited, if they will be rewarded, and if they are very fertile mind, that they will try to use more and more inventions, they will try to apply their minds so that they may able to get more and more inventions and innovations. So through this, the creativity will be enhanced, and we people will able to use more creativity, and we will reduce the imitating mentality of others. What we are doing, we are imitating others. So instead of imitating others, you must provide the leadership, and the leadership will be provided only when we will become innovative. IP protection spurs international trade. When we talk about international trade, we talk about imports and exports. So here the important point is that when we talk about imports and exports, what is the Atmanirbhar Bharat, that our Prime Minister has also realized that our predecessors are not capable to compete with the global trading. It means that we are depending on other countries in terms of the products. So what he said, that there are the two parts of the international trading. One is known as the import. We are importing products from other countries, and we are exporting. So since independence till date, if you see the situation, that always our imports exceed over exports. So what is the position? We were not able to compete in terms of the technology with the developed economies. Then he said that, okay, what we should do, we must produce a product which we are importing from other countries, so that we can save our precious foreign currency. So he's saying like that, Atmanirbhar, it means that we should reduce our dependency on foreign products. So we should produce these products within the country, so that we may able to substitute the imports. Okay, we are not capable to face the competition. If we are not enhancing our export, at least we must reduce our imports, so that we may get self-dependency. We may go towards the Atmanirbhar, and we can save the lot of currency, and that will be possible only when we will come through the new ideas with the new inventions and innovations. The IP system helps strike a balance between the interest of the innovator and the society. So the person should develop such type of technologies which may help the society, which may help the people, not destroy the society or the people, like weapons, missiles and all that side. So when you see the ethical issues that will come under the this IPR laws, that by using these technologies, the researchers, they must avoid such type of things because that will go against the interest of the human race. So these are the history of IPR in India. These are the various laws, regulations, and these are the laws basically in India before the WTO. In the beginning, I told you the WTO, and after the WTO, 3 more laws were added: geographical indications, layout designs of integrated circuits, protection of undisclosed information. And presently, these are the laws in our country as far as concerned the IPR laws. This is the latest position: patents, copyright, trademarks, design, geographical indications, layout design of integrated circuits, protection of undisclosed information, and new plant varieties. So these are the laws in our country we are having since independence till date under the new regime of the IPR. So this is the new IPR policies. Due to the shortage of the time, I am not able to discuss this IPR policy. So that's all about my presentation. Thank you very much for joining my presentation. क्वेश्चन लेने तो बताएंगे.
Sir, Professor Rajendra, kindly unmute yourself.
जी मैम. हेलो. हेलो. गड़बड़ हो गया
बोलते रहिए.
हेलो.
फीडबैक दे रहे हैं.
ये तो फीडबैक से तो मतलब क्या लेना होगा.
Sir,
हेलो.
sir, are we audible?
जी मैम.
Sir, there are certain questions which the participants have typed in the chat box. If you're comfortable, you can answer them.
Yeah, I'm comfortable. Go ahead, but be quick because I have some another meeting just now.
Okay.
Sir, the question is by Rajesh Kumar Jha. Please let me know the difference between trade dress and industrial design.
Trade west and trade and industrial design.
No, I'm not following your question, ma'am. Please repeat. Repeat your question.
What's the difference between trade dress and what is the difference between trade dress and industrial design?
Difference between trade?
Dress and industrial design.
No, trademark and industrial design.
The person has written, one of the participants has written, what is the basic difference between trade dress?
Trade gap. I'm not following your question. Trade gap.
Trademark and industrial design.
Oh, trademark, that I think that they have not listened to me carefully. Trademark to identify the product in the market, to differentiate the product in the market. I have quoted the example. Say for example, when you talk about the Tata, this is the trademark of the Tata group of industries. Industrial design, this is the outer look of the product. It is not related with the technical side, basically outer look of the product, the aesthetic aspects of the product. Trademark, that some name, some title will be given to the product. So this is the difference. These are the 2 laws. Any more question?
So the question is related to the registration process of GI.
Okay, what is the question?
Sir, it's about the requirement and registration process of GI. Like, how do we register it?
I have told you that office is in Chennai. There is only one office in India, in Chennai. You open the website, you will get the whole procedure. And I have told you also, it is a common right that manufacturers, they will form a society. Then society will file the GI. Individual producer, manufacturer will not file the GI. Okay, it's the community right basically.
Sir, thank you very much for taking us your valuable time. We had planned the inaugural session, but because of sir's busy schedule, we couldn't do that. But sir, it was a wonderful talk. Too much information we have gathered. So thank you very much once again.
Okay, thank you, ma'am.
Okay, sir. All the participants, the next session would start at 2. So kindly log on before 1:45.
Hello. Good afternoon, sir. Sir, please unmute yourself. Naresh, sir. Please unmute. Good afternoon, sir.
Hanji, good afternoon, ma'am. Good afternoon.
Welcome to NIT Jalandhar.
Thank you, ma'am. Thank you.
So should we start?
Yes, you can go ahead with it, please.
Okay. Good afternoon, all. Our speaker for today's afternoon session is Professor Naresh Kumar Vats, who is a professor of law at Rajiv Gandhi National University of Law, Punjab, Patiala, and registrar also. Prior to joining at Rajiv Gandhi National Law University, he worked as the head of the Department of Law, founder chairman CPG-LS, head center of IPR, and he has been teaching intellectual property laws, family law, commercial arbitration, mechanism and cyber law at undergraduate and postgraduate courses at various institutes of India. He has delivered many special lectures on artificial intelligence, IPR, family law, taxation, and business law in MBA course and some refresher courses. He also served as head center for IPR studies in BGS Trust University, Bangladesh. Professor Vats also served as secretary of National Seminar and campus of Rural Lok Adalat and Legal Aid Clinic. And he also served as coordinator of WIPO India Summer School 2017 between WIPO Geneva, RG IIPM Nagpur and MNLU Nagpur. And he has also hosted WIPO India Summer School 2018. Welcome, sir, and sir, please start.
Thank you, Dr. Sadika Kular, ma'am, and all the supporting staff, the members associating with the short-term course hosted by the NIT Jalandhar. Very good afternoon to all the friends and the teaching fraternity. I first of all thank you, NIT Jalandhar, Dr. Sadika ma'am, and all the members associated with the short-term course. Dear friends, let me just have the feedback first of all. Is it my PPT visible?
No, sir, PPT is not visible.
Okay, it's not visible.
तो वहाँ पे YouTube वीडियो भी दिया है ना? People who have some kind of problem, they can see it.
Is it visible now?
No, sir.
Could see from there, right? Sir, why don't you understand?
Yes, ma'am.
Yes, sir. It's coming.
Yeah.
Now it's visible.
Thank you. So dear friends, first of all, I'll be just discussing on the trademark law and the role of the consumers, which is in the present scenario in the society, it is playing very important role. The trademark, what is the understanding of the participants on the intellectual property, particularly this domain of the trademark. This trademark, what we understand about the trademark, you just read it. The mark, because we are a consumer, and being a consumer, we feel that whatever the item, whatever the consumable item, goods for the daily, day-to-day use we are using, what is the rationale behind it, for using it, for consuming it, for buying it? The rationale, maybe the product, maybe the services, anything which is consumable or usable by the society. These are the some of the products, like if I talk of the toothpaste, which toothpaste, which brand we are using, why we talk of the brand, whether it's a Colgate or Aqua, Sensodyne or the Close-Up, means thereby if we talk okay, this is the toothpaste, I want the toothpaste. Toothpaste means directly it does not specify a particular product, but the impression in the today society and the imprint which we are having today, that imprint is okay, yes, the Colgate. That is the imprint we are having. Or otherwise, because we are in the competitive world, this competitive world, we have been facing the different products which are available in the market. Maybe the Aquafresh, maybe the Sensodyne, maybe Close-Up, or maybe Dantakranti, blah blah. Or otherwise, when we are talking of the washing machine, maybe the particular brand is there. Whirlpool, LG, Onida, Samsung, or the Blue Star, etc. Or because we are nowadays more used to using the telephone, mobile, or the computer, maybe the Nokia brand, maybe the Samsung, maybe the Moto, maybe the Apple, OnePlus, Dell, HP, Micromax, Lenovo, Asus, or any brand. Sweet, if you are talking of the eatables, Haldiram, Bikaner, or Chitale, or Bandhu, or the beverage, Coca-Cola, Pepsi, or Rasna, or the fruity. Or we want to travel. By traveling, we think of which flight we use, which will be more convenient, which will be giving you the more facilities. Maybe the airlines, sometime one may not prefer the airline, Air India, or Indigo, or Jet Air, or any other airlines. Or the meal while taking the meal, Dabbawala, or otherwise Naan and Curry Express, or Jain Food, or otherwise for the services, for safety, for social security. We think of why not to at least have the security, and what kind of the security, social security, at least during the lifetime. Definitely many number of the agencies are in the market, maybe the LIC, maybe SBI, or HDFC, or ICICI, or PNB, or otherwise for your own utility, which brand of car, which car we will prefer. Maybe the Maruti, maybe Hyundai or maybe Nissan or BMW or Tata, whatever it is. Footwears, Nike, Bata, Liberty, Relaxo, Woodland. Means thereby when I'm talking of these brands, these products, what impression gives in your mind? Why we are behind these particular product or these services? There might be some reason, and that reason is either because you are particularly for the originality, or you are looking for the betterment. Okay, yes, the services will be much better, or otherwise at least your utility, means anything that can be. So that is at least the impression in the minds of the consumers, in the minds of the users, that impression is there. On the other hand, when we are going on the trademark part, a partly introductory part, the brand, when we are talking of the intellectual property, trademark, it's a very synonymous of the brand name. Means trademark is the one mark, and branding itself is another process for the after getting the registration. How do you brand your trademark? Maybe the Pepsi, maybe the Coca-Cola. If any of the brand, any of the trademark which you feel, okay, yes, this is the trademark which is catchy or which can attract the minds of the users. So that may sometime you have to brand it. And making a distinction, the other part, okay, yes, you have to be very clear from the one product or the services of one brand to the product and the services of the other brand. That is the sole purpose of the trademark. If I say X and Y, or Y about the beverage, the Coca-Cola or the Pepsi, why I am talking of the Pepsi, why I am talking of the Coca-Cola? What is the distinction? What flavor, what taste it gives you while consuming? Definitely you will be the best person as a consumer to make a distinction. Okay, why do you prefer the Coca-Cola? Why do you prefer the Pepsi? Or otherwise any services or any product? So it is because, okay, even if the mark which you feel, okay, yes, this is the mark, you will identify, okay, without the mark, otherwise if you remove the mark, it will be very similar to the other. You will not be able to distinguish between one product to the other product, or the services of one product, the one proprietor to the other services of the other proprietor. We will not be able to distinguish it. Then somewhere some uniqueness is there, some distinction is there. Then that is the reason we are able to use it, we are able to grab it, and we are able to purchase it. When we are talking of a Maruti, why you, me, or anybody prefer Maruti? Why we prefer burger? Why the other product? Means if we are talking the distinction Maruti versus Nissan, why Maruti it is? Somewhere some distinction is there. Nissan probably, yes, might be the higher class society, the people those are having the high income society, they only prefer the Nissan. Or otherwise a common man like me, sometime, yes, I go ahead with the Maruti only. Because the Maruti is that product, anytime, at any moment, you can just start it and you can use it even if it get the fault. Sometime, every mechanic on even the road, the people are there to just rectify the fault. Maybe that way, or otherwise it is more convenience to my pocket, expensive friendly, economic friendly, or otherwise the parts are easily available. So that may be a different USP every product have. When we are talking the word means the trademark, mark either a Maruti say logo, or otherwise when we are talking a word, the mark may be even as a word, and that word is like a burger. Burger is another word actually, and which is catchy, which leave the impression okay, yes, this is another kind of the product which give you the services, a particular service or particular product. So that is the even a word that can be the mark, or otherwise a phrase. When we are talking of the phrase is also a mark. Even sometimes if you remember it, कि कर लो दुनिया मुट्ठी में, means everybody cannot have that mark, everybody cannot have this hashtag, the tagline. कर लो दुनिया मुट्ठी में means somewhere it gives in the it click in your mind कि whose mark is there, whose phrase is there. Somewhere when the Reliance took this the market of the wireless or the technology or a mobile, means then only they started it. Or otherwise a logo, say Maruti S when we talk of, or otherwise the other one Volkswagen, or otherwise a symbol like a Twitter, like this logo of the Apple, or otherwise design can also be marked. Means somewhere that design, particularly the Adidas, you understand it कि this is the Adidas, this product, maybe the shoe, maybe the your jacket or any of the product, you identify having that particular mark, yes, this relate to the particular brand. Or otherwise image like the Nike, or a combination of the colors, means any color or any combination of the color, not a particular single color cannot mark, because we have to make the distinction when we understand it, okay, the mark which appear, which give the originality, which identify, which give you the from where it originated, or it make a distinction between the one user to the another user. So at least the consumer must know, okay, yes, this particular product is originated from a XYZ, or this particular product is relating to the particular person. So that is the purpose of this particular mark. Like if you are going at these categories of the marks, maybe the fanciful, the mark may be even fanciful, like Adidas, or otherwise arbitrary mark. When we are talking of the fanciful mark, somewhere it is attracting the consumers, and that can be even protected, that can be even registered. Or even arbitrariness, means you don't have anything other than the logo. Whereas when we are talking of the apple, it originally it relate to the fruit, but we cannot have that fruit as an apple. We cannot have the logo, the trademark for the apple. It is because it is dealing with the different work or different product or the different services. Or otherwise the suggestive one, like the north face, means somewhere it is suggestive word, it is suggesting the users कि this is what the way, but which is not even protectable. Or somewhere descriptive one, Pizza Hut, or otherwise somewhere generic word, chapstick. So generic word cannot be protected. Like the apple, if we say the apple, and it is protected for the basket of the apple vegetable, so it cannot be, because being a generic word. So generic word cannot be protected for the purpose of the trademark. Or otherwise, when we are going another product here, like identification, whether the mark is a registered one or protected one, or simply just it's the indication given to the consumers. A mark used by one businessman to distinguish its product and the services from the others. Means the purpose of the mark is making a distinction between the product and the services. The proprietor may be the product manufacturer, proprietor may be the service provider. So if the services are provided by the proprietor or the products are manufactured by the proprietor, so it is making a distinction between the one proprietor to the other proprietor, services and the goods. So sole purpose is that, because as a layman language, if I talk, one cannot be identified without the name. You, me, and everybody, because everybody is having their own name, which is assigned by their own parents or near and dears. So they identify, they call by name. It is not 1, 2, 3, 4, 5. If we just give a name to everybody, rather than giving a specific name, 1, 2, 3, 4, 5. So and numbers, it will be n numbers, and it will be very difficult to remember and to just have their identification. So better to yes, the mark is given, and the proprietor, the originator, means our parents are the proprietor, and we are their product. We are their product, and that the mark which they have given in the form of the name or as a product. So that is the mark which we carry. Or valuable assets or the traders of the business, means maybe the businessman, maybe the traders somewhere, even if as a services which they are providing. So they are identified by the particular service mark. The primary function of the trademark is to identify origin or the ownership of the goods or the services. Means one can easily identify, if I talk of the Colgate, Colgate means the origination of the Colgate from the Colgate company. Or Maruti 800, different brand is there. So it is the product of the Maruti. Identify it, we learn it, and how do we understand it? Okay, this is the encircled R. If any of the product, whatever the water bottle is lying with you, you just pick up the water bottle, maybe the Pepsi, maybe the Bisleri, whatever it is, with the beverage you are having, you just see it whether it is having the encircled mark or with the particular brand, particular trademark. So you identify if it is encircled, it means that is protected and that is registered trademark. So that registration you will be finding, you will ensure that. Take this example, just identify why do we talk of this encircled BMW? Means what? It is what? BMW. BMW, is it somewhere edible word? Or some the hosiery? Or some services? Means one can at least easily identify that BMW is a brand of the car manufacturer. It is the manufacturer, and this is the logo, this is the mark they carry with their own product. Maybe the Coca-Cola, beverage, or anything, any gadgets, or any the product, your consumer products. So they will carry that their own product, like a Coca-Cola. Or otherwise, you can even make a distinction. Okay, if it is not encircled with the R, you will understand is okay, it is encircled with the TN. The trademark means thereby it is not yet protected, it is not yet registered. Means the process, it is in the process. In the coming days, the may be registered or may not be registered. On the other hand, these many products, these many brand you might be, the marks you may come across, you might have come across. So why these particular marks you learn, okay, yes, this particular mark, I believe, okay, this is the product I like. Why Coca-Cola? Why McDonald's? Why BMW? Why this tick mark? Why Benz? Why Pepsi? Means something, at least if something goes wrong, say it is not BMW, but if it is starting from WMB, the words are same. But if they are reversed, so will it be appropriate? Will it carry the same meaning? Or otherwise, if the tick mark, Nike, if it is not tick mark, that way right side, starting from the left to right, or if it is ulta, starting from right to left, is it possible you will carry that same image, same impression? This particular brand is relating to the Nike. Will you like to purchase the particular product? Will you consume it? Will you object it? So this is the rationale behind the trademark. Yes, whatever is received, whatever the image is carried by the consumer and whatever is registered, that should give the proper meaning. Because if my surname is Vats, or somebody who pronounce me not Vats but, like, because some of the Bengali peoples, they don't have the vowel V. They call Bhatt. So is it, sometimes it may not be comfortable to me. I may not accept it. So the reason is, yes, whatever the proper name is given to you, you take that name, you accept that name, and you expect the people must direct you, must indicate you. They must know it. So we cannot make it ulta, WMD, or otherwise logo make starting from the right to left. It's a kind of a deception. It might deceive the people. It is not a product, that product. When we are talking of the Colgate. So you say the Colgate, COLGATE. Maybe one word is missing or replaced by some of the other words. Colmate. So will it be appropriate to us? It may not be appropriate to us because somebody might be manufacturing the Colmate, and which is again in the competition of the Colgate, and which is not comfortable to the proprietor of the Colgate. May not be. Definitely it will attract the prosecution. So one cannot do that. One cannot deceive the consumers, because we carry the faith and we love to win the faith of the consumers. There is a image, there is a loyalty, and there is a relation between the consumers and the manufacturer. Whatever you expect, so we try to we try to at least build the relation between the consumers, and that relation is the confidence. That relation is of the loyalty. That loyalty, okay, yes, whatever is your demand will be fulfilled by my particular product. So therefore, we are going ahead with another trademark. The first trademark give in UK the trademark in 1876, Baslet. Triangle was the first trademark. It was in 1875 when the trademark was started, and it was started believing and establishing the relation between the consumers. Okay, this is the mark, and people understand it. Okay, this is the particular product which is being accepted by the people, and the purpose, because it gives you the quality. Believing, okay, yes, you believe in the quality. If you are using a particular product, so you believe it. Okay, yes, it has the quality. It has the authenticity. Okay, yes, Mr. X is giving the particular product. Mr. Y is giving that particular product, the services. Feeling the trust, okay, this person will not cheat me. This person will not mistrust. And it will be adding the quality. It will be adding to the particular, say, the services or the quality. So therefore, when we are talking of this trademark, so the purpose is to make a distinction between the goods and the product of one person to the another person, and it is added value to the business, because people are running the business. If they don't have the if they don't have the full, okay, I got the message. If they don't have the mark, if they don't have the brand, sometimes it will be difficult to them to compete in the market. There are the competitors, there are the proprietors who don't have the trademark, and simply without the trademark, just a goodwill they are making. Just on the goodwill they are going ahead. And with the goodwill, when they are going ahead with the goodwill, so they try to win the faith, either because yes, believing yes, the product, whatever he is giving, or the services, whatever he is giving, definitely the product and the services are satisfactory, and they are fulfilling your need. On the other hand, the originality and the originality, there is no adulteration, and it is originating from a particular place. So that's what you are carrying, and it gives you the product distinction, personality of its own. Because if you are giving the product and you are serving the particular product in the market, so that is what the personality. It is your personality. Believing it is your personality, and that personality you are not likely to cheat, you are not likely to say create any problem to the consumers. Means you are loyal to the consumers. You are fit to give the service to the consumers. You are acceptable by everybody, and that is the reason people will love to have you. If you are giving with the particular product, with the particular mark, that identity, that personality. And people identify, okay, yes, when we are talking of a Dabbawala. So why do we talk of the Dabbawala? How do we hear from the Dabbawala? From where we hear the Dabbawala? Means somewhere at the back of mind, okay, why it is Dabbawala? Means somewhere in particular territory, some particular region, okay, yes, Dabbawala is that person who is giving the services for the fresh food, fresh meal, anytime, at anywhere, or within that particular region. So you believe it, okay, yes, this meal which is served by Dabbawala deems to be the fit one and eatable. That's good enough. So that is the perception of the consumers. And the means of the trademark means the purpose of the trademark even, okay, yes, the trademark must be visible to all, to the users, and it should be represented graphically. Because after induction of the trademark in 1999, the Act, the changes which are brought under this provision, because we are not in the traditional mode of the transaction, we are in the mode of the e-commerce also, electronically, we are in the cyber world. And in the cyber world, by sitting here, it at a particular place, it is only feasible because of the information technology that I'm with you, and you can just listen me and I can listen you, because of the information technology. Otherwise, the NIT Jalandhar has to bear the expenses of coming and going, and it will take another 4 to 5 hours for me traveling from Patiala to NIT Jalandhar. So it is just only sitting across the world. One can at least make a communication, one can make digitally disseminate the information. That is the only reason, because of the information technology. And if the trademark is graphically represented, okay, at least by with the image, if it can be represented, okay, this is what the website or this is what the trademark is there. And if anybody is clicking with that particular trademark, means I believe, okay, yes, this is what my desire. I want to have this particular product. So that is what is there, and which is capable of making a distinction between the goods and services of one person. Maybe the color combination, maybe separate, maybe the different colors, not a unique color. So one cannot have the absolute, absolutely having a particular color of the trademark. No, it is not. On the other hand, when we are talking of this mark, it may be even the different shape as a device. Even it can be as a device also, and the device can be, even the label can be there, even it can be in the name of the phrase also, it can be in the name of the logo, means which is not in the word format. And the device that can be even which is fixed, or otherwise brand, any brand. Maybe when we are talking of the brand, it may be a Colgate, it may be a Apple, it may be a Coca-Cola. So that is another brand. That mark can be of that mark, or otherwise heading in the the alphabets, or otherwise the label, any label, mark, or the ticket, maybe different form, the colors, combinations, or how do you format the ticket, how do you create that particular ticket, or the name like Nike, like WhatsApp, or otherwise signature. Your own signature can be your own mark. If it is a unique, if it is distinguishable, if it can be a marketable. Hello? Is it audible?
Yes, sir, you are audible.
Okay, because I'm getting some messages.
No, you are audible.
Yeah, thank you. Going ahead with the goods, what goods are there? Goods, we understand the subject to the trade and the manufacture. Means thereby it can be a tangible also, it can be, it is usually tangible, not the intangible. And tangible which we can see, which we can use it, which we can feel, or the services, how the services can be there. You making a distinction between the goods and the services. Services, it can be in the intangible form. The users of the services may be the bankers, banking communication, banking, maybe the communication, banking loaning, or otherwise the insurance, or the communication service, Tata services, BSNL services, or the Reliance services, or the education services, or the financing services, chit fund, or real estate, or transport, storage, material, treatment, blah blah, lot many services that can be even to the extent of the construction and the conveyance of the news or the information of the advertising. And today when we are talking of the cyber services, the internet services, so that can be even the services. And why do we talk of the particular trademark of chit fund only, or otherwise insurance? When we are talking the insurance, means does not mean it is a LIC. Means of course it gives you the message ke Life Insurance Corporation, and it is not only that insurance which is done by the Life Insurance Corporation. It may be even the SBI insurance, it may be even the PNB insurance, it may be any other bank's insurance, or it may be otherwise Max insurance. So they have distinguished it, and but they are in the particular insurance services in particular sector. Like if you are going ahead with the trademark, typically you just understand it कि maybe the visible and non-visible signs. The trademark, it can be the conventional or non-conventional mark. Conventional mark which we are day-to-day facing, day-to-day experiencing, or able to at least see, are able to touch it, and we can experience that this is what the conventional mark. The other marks are the non-conventional also, which is not the conventional, which cannot be seen but can be even learned, which can be even sensed, which can be even heard. So like the Facebook, it is the conventional mark, or the Fair and Lovely, McDonald, or Reebok, eBay, Gmail, KFC. So these are some of the marks which you understand why Facebook you are talking, why the services of the Facebook, why Fair and Lovely only, why Reebok only, why not Nike only, why not Liberty only, why KFC, why not the McDonald. So you can make a distinction between it, and why Gmail or the Yahoo, why the others are not there. When we are going with a specific provision under the Act 1999, the Trademark Act, it is talking of the even associated mark, because mark individually one can have, but another the term which is defined under section 2C, it is talking of the associated trademark, and it clearly make a distinction between the associated trademark, the trademark deemed to be or required to registered as associated trademark under this. Means somewhere this mark, trademark Pepsi, was filed in 1994. Both these marks were filed in the same class with the same specification of the goods, and obviously by PepsiCo. Since the mark filed in 1997 was 3 years later than when the word mark was filed. At the time of examining the mark, the registry required the PepsiCo. Means thereby, like if you see the picture of the Pepsi, that is the device. And again, along with the device, the PepsiCo is also associated with it. So you will understand that not only that particular dabba of or bottle of Pepsi, but along with the Pepsi, along with the color combination, the gold wala jo color combination aata hai, so that is again it is associated with the PepsiCo. So this is association with the particular product. This way, I'll give you an example there. I'll be coming with the particular slide you will come across. On the other hand, we will be having the certification of the trademark. Means thereby somewhere some mark, trademark, then again there are the certification of the mark. Certification mark, which is the particular organization, the particular which give you the certificate. We certify the quality, we certify the utility and manufacturing facility of a particular product. Okay, whether your particular product or the services is qualifying with particular factors or not. If it is not, sometime like ISO, Indian Standard Institute, it also gives the mark, or ISO mark, means thereby it gives you the particular certification. Okay, it is fulfilled with the particular ISO. It is fulfilled with the ISI, like our educational institutions. They are graded NAC A, B, A plus, B, C, whatever it is, A plus plus. So that is the certification. That certification because you have attained that particular examination, you have crossed and you are qualified and you deserve for this particular distinction, like we are giving the grade. When a student is qualified, so we are grading them. Between this marks to this marks is equal to this grade. Then between this marks to this mark is equal to this grade. So that particular certification mark, similarly in the goods and the product, you will experience, okay, yes, the ISI mark is also there, ISO mark is also there. As a collective mark even, as a collective mark, I'll be dealing in the next slide elaborately with the collective mark. Whether the trademark, it should be registered or not registered. What is the utility of the registration of the trademark and the non-registration of the trademark? The reason is, okay, sometime because we are in the competitive world, and in the competitive world, definitely if we have some production, it is the production with the registration only. If we cannot make any production, we cannot claim any damage from the infringer if we are not registered. So therefore, the registration of the trademark, it is essential, and that registration, it gives you the benefit of at least prosecuting the infringer. You will be getting the certificate, and the trademark registry, it will seek the information, application online, and while filing the online, then they will be examining your application. And after examination, they will understand whether your mark is eligible to be registered or not. Based on all the criteria, that mark, whether it's a device, whether or a label, or a ticket, or otherwise a word mark, or otherwise whether your mark is making a distinction between the product, your product and the other products. If you are working in the biscuit, whether your biscuit, of course biscuits are the biscuits, you will enjoy the same taste. Might be sometime हो सकता है कि आपके पास में इलायची डाला हुआ है, दूसरे वाले ने इलायची के बजाय पुदीना डाल दिया है उसके अंदर. Might be the different taste. Might be the salty, might be the sweet, might be the salty. So different taste may be there. But how to distinguish it? Merely not by the taste, but identifying from where it is originated. Who is the manufacturer? And that manufacturer sometimes is the symbol without the label, without the mark, the product is presented to you. It will be very difficult for you. So therefore that particular mark is there. And that mark maybe on one biscuit, sometime you give the particular mark. On other biscuit, sometime you give the mark. And here it is, like even because the trademark, it is then earning the brand name also, it is earning the goodwill also. Your goodwill along with that, then only it is branded. And the impression to your customer that the company is selling some standard product or the standard services if you are having the brand, if you are having the trademark and good services. Your value, it will be increasing in the market. So you can sell your product only then when you are having the high value, you can stay in the market. But merely high value, no quality, sometimes definitely you don't have the space to stay. Sometimes the people has to say bye, thank you. Sit at home. We have another competitor. We have another substitute. So we can purchase that one. So these are some of the this one procedure. Online registration for the registry to the trademark, specific fee along with that, and the registry of the trademark, they can make an objection. If it is not a distinguishable, then sometime it may reject it, and you have to just modify, you have to present the separate application. And if it is yes, then it is accepted. Opponent maybe ask the opposition application. And if somebody is having the opposition, then you have to justify it. Or otherwise, if it is still the registrar of the trademark registry is not happy, sometimes he may ask, he may reject it. But before making the rejection, then he will call you also. He will ask you because, yes, he is to satisfy from your response. Or if you are able to make him convince this is what the reason, this is what the distinction is there, then you can just can be qualified. Very clearly, very clear. There is a case of Britannia biscuit, the case, and therein what happened? They manufactured utterly biscuits, and that biscuit was presented. And somewhere there was the picture on that biscuit, the logo on that biscuit was a small baby, actually, smiling baby. Baby was smiling with smiling, and somewhere not only smiling, uske jo in between one milk tooth that was not there actually. It was open. So while eating that biscuit, the baby, they enjoyed it. On the other hand, similarly the competitor, they also manufactured the biscuit, and there they copied somewhere some similar picture. Only the distinction was yes, one smiley child is there, and smiley is there, and the child, his one eye is closed, and the tongue was outside. Means somewhere like जब हम अपनी मतलब कई बार क्या होता है कि अपने स्वाद के अंदर आई एम कमिंग डाउन टू हिंदी जस्ट टू मेक योर अटेंशन कि यस समवेयर जस्ट कभी आपको कोई अच्छी चीज लगती है, स्वादिष्ट लगती है, तो उसके अंदर क्या होता है कि आप दूसरे को एक्सप्रेस करने के लिए एक आंख बंद कर लेते हैं कि हाँ क्या मीठा है, क्या स्वाद है. Similarly, that message was given by that baby. Okay, yes, it's very delicious. Closing one eye and taking the visibility of the tongue. So there he prosecuted. Okay, no, this gentleman manufacturer must be stopped. He should not bring his product because he was in competition. And ultimately, when the matter went to the court of law, and the court analyzed by stepping themselves into the shoes of the baby. And after stepping into the shoes of the baby, when they made a distinction, okay, no, it is very clear and it's a distinguishable. One can make a distinction between this product and this product because of this baby. One baby is just smiling, only smiling. With that smiling, one can enjoy it. On the other hand, the baby which is smiling, closing one eye and tongue outside, it is distinction. So that become catchy to the consumer, a group of the consumer, group of that particular that product. So that way, while we're making the register, then the registrar, he make a distinction and he can just feel by seeking the opposition from the applicant whether this particular trademark is registrable or not. So that is the way of making a registration, and this symbol you understand, yes. When the registration is made, this registration, it will be for a 10-year initially, and after the 10-year, after making a payment, it can be even extended by making a payment of that particular trademark. This mark will be there, this mark will be there, this mark will be there as a trademark. So I'll be just coming with the more examples like the trademark. You understand it, okay, which make it capable, making a distinction, conveying the message with the images or some quality or the value or somewhere from where the product is originating. From where the product, just sorry. Yes, sir. नहीं सर all is fine. No matter, sir. No. Yes, sir. Right. I'm sorry. There was a call. So that is the sole purpose. The message is. Yes, sir. उसको मिसी जो आपने भेजा था मेरे को ना yes right sir it thank you wonderful take so at least the consumers, it is convenience to the consumer. It is not a convenience of the manufacturer or the proprietor. Because the manufacturer or the proprietor, they will try to grab the market, they will try to dump their product just to take the money out of the pocket of the consumers. But the consumers, the court says, okay, the consumer must be well acquainted with the product, with the services. What kind of the services are there? Is it not misleading to the consumers? Or the product making a distinction between you? Okay, why your product should be sold? Why your product should be purchased? You make a distinction. Like the Maggie, like Pepsi, like I was saying, okay, this is what the word mark which is associated, or the Philips. So the purpose of the trademark is just making very clearly who is the personality which carrying the personality, or which is conveying the message, which is conveying the image or the origin to the consumers. These are some of the indication for your convenience. For the trademark, I discussed with you, which is unregistered trademark. You will get this symbol, or otherwise the same way the service mark. You will get this service mark SN, which is unregistered. And if it is registered, then you will get the R and circled with. The category of the trade certificate. Category is certificate trademark. Certification, okay, yes, this is what the quality of the certification. Like BIS, when we are going for the market, when we are going to the jewelers, to at least BIS hallmark, you will like to, the ladies, they will definitely like to, and you as a male spouse, you will definitely like your spouse should carry the standard gold. Standard gold. It should not be not less than 24 carat. Maybe you can just compromise the 23, but not less than that. Otherwise, unless it is having the stamp of that, or otherwise, if it is like FPO mark, the products, or otherwise AG mark, or ISI mark. So this is the quality, this is the certificate trademark which give you the certification. Or otherwise, the collective mark. Means thereby the collective mark is the mark which is of the goods or the services, making a distinction, but in association, member of the associations, the persons, those are in that particular association they are using. Like the collective mark, when we are talking the chartered accountant, it's a class. The people, those are of the chartered accountant, they are getting the CA. Why they are CA? So this is a class, this is the collective mark they are using, like LIC. So they are using this particular LIC agents or otherwise the advocates, they have this. This is a collective mark to the particular association, to a particular organization. They are representing that particular organization. And just be very clear, the collective mark and the certification mark. How do you make a distinction between the collective mark and that certification of the mark? Collective mark, and which is owned by the organization and used by members to identify them, like CAs. It's used by those members, those are associated with the particular organization. And the certification mark may be used by anybody who complies with the standard defined by the owner of the particular certification mark. You as a you as a jeweler, you as a proprietor, when you are launching your product, you will like to have stamping that your product either with the ISI or if you are a jeweler, definitely with the hallmark. So you will make that use, but the hallmark ISI is given by the particular certificate, the certifying agency. That particular certifying agency, it will certify that yes, the purity of that gold is there. Or otherwise, another definition, if you make a very clear, the collective mark adopted by a collective, that is by an association, a union, or a cooperative fraternal organization, or other organized collective group for the use only by its member. These members are using because they are associated with the particular organization. So they are having that mark. Or otherwise, the members use the mark to identify their goods or the services. They are making a distinction. Okay, this is what the advocate, this is one the person chartered accountant. And the collective mark itself neither sell the goods nor the perform the services under the collective trademark or collective service mark. But collective may advertise or otherwise promote the goods or the services sold or rendered by its member under the mark, because that is the regulatory agency, the CA or the bar council or the advocates. So they are the professionals then for that. Similarly, as a member adopted for the purpose of indicating the membership in an organized collective group such as union or the association, that is another association, or like a INTUC, or neither the collective nor its member use the collective membership mark to identify or distinguish the goods or its services. Sole function of a mark is to indicate that a person displaying the mark is a member of the particular organized collective group. So this is what. Coming to the another part, what you might be experiencing, you might have faced, you might have experienced it, you might have been cheated because of these products. So this is what is prevailing in the market, and which we term here deceptive similarity. Deceptive goods means somewhere why the Trademark Act is emphasizing on a trademark registration or trademark which is not able to make a distinction, it means that is not registrable. And like the deceptive similar trademark, the people, the consumers, they feel like I gave you an example of the Colgate and the Colgate. Means the only the pronunciation or otherwise having impression that only mistakenly one word is missing and replaced with the G. So if my friends they are more using the product, Apple product, this is what the Apple actually. So you will experience which Apple it is. This Apple or this Apple. Don't get confused. Both are Apple. Both are Apple. But one may be the fake and the other one may be the real one. If you see your own Apple product, you will just respond me. If anybody has unmuted themselves, so which is the original one? Anji, can anybody let me know which is the original one? Gray or the black? Yes, please, one of you can just unmute. Let's make it a little interactive.
So they're writing in the chat box. Someone is writing gray and I think Hassan has written black.
Why it is the black and the gray? And what about your opinion, ma'am?
I think the first one.
First one?
Yes.
The black one?
Yes.
And the left one? The gray one?
I think that's the deceptive similar one.
Correctly, that is the deception. Very true. Thank you, ma'am. Thank you. Because, of course, the Apple is there, the cut mark. I also got confused actually. I was traveling on the way and fortunately some of the vendor came to me, sir, please, this is the Apple product, very cheap and this and that thing. And having that impression, it was a very new one which was lost. And I thought it came very at a very cheaper rate I am getting. I got it. I purchased it. And after comparing and reaching at home comparing, this is what the Apple, and my son said, no dad, you are cheated. And having that impression, why? How I am cheated? It's Apple. No, daddy, this is not the Apple. Because this is ulta cut and the sidha cut. One is the right cut and on the left cut. And the cut on the right side is the correct one. This gray one is the correct one. Because the cut mark, you just imagine that the cut mark is on the right side. Means the right side cut is the right one. Left side cut is the wrong one. So I have the wrong one. And fortunately, that's still working. So just for the example, actually I am carrying it. Okay, this is what the people are got cheated. And similarly, yes, this Nike product, these are the two Nikes. The symbol is here, tick mark, and beneath one is Nikah and the other one is Nike. So you will surprise yes, if you are going in the market and finding yes, Nike and Nikah is there. So which one you will like? Definitely which is the cheaper one. Or otherwise you are smart enough and you are a man of the IP, you will understand this is the fraud and this is the deceptive product available. Nikah is the deceptive. Or sometimes even if Nikah or the Nike is not written, you will find yes, the right tick mark or the left tick mark sometime you may find. You will find yes, tick mark is there, but Nike is not written, but only the tick mark having impression Nike product is there. So don't get cheated. Be cautious while taking the product in the market. Okay. Even then, this is another concept of the passing off actually. Nikah and Nike, or this one Apple, means the passing off. This is another say infringement, or because the principle of the passing off, it says if it is your product, you have the right to sell it and you must own the responsibility of the bad and good. If it is working well, you will enjoy the benefit of it. If it creates a liability, then you will be prosecuted for it. And if you are decepting the consumers and somebody is passing off your product and selling his product under your impression, that is the passing off. Means if somebody start selling this product, Apple, in the name of the Apple, original Apple, okay, this is also Apple. So this will lead to the passing off. And this Ulta Apple, this person, the proprietor, he can be prosecuted, he can be fined, he can be jailed, he can be charged for it. Similarly with the Nike and the Nikah. So the person who is decepting, who is passing off his product under the registered one. So this passing off is based on the principle of man may not sell his own goods, deceiving that they are the goods of another man. So one cannot sell his own goods deceiving the people that this is the product of the other person. One cannot. Similarly, Section 27 under the Trademark Act, it gives the right to action against the person for the passing off, to prosecute him. Section 134, 1C, for the jurisdiction of the court against whom the passing off arising, and says Section 35, 135 specify the remedies available in respect of passing off arising from the use of the trademark as a concept of tort. It is a tort. It is a wrong which is done. Grounds of the damages are the goodwill, misrepresentation, and the damages. Because if somebody is damaging your goodwill, somebody is misrepresenting you, somebody is damaging your economy, then you have the right to prosecute the person. Because you have built up your own image, you have built up your own goodwill in the market, you have developed your own standing in the market. The product or the manufacturing of the services or the product and establishing the loyalty to the consumers. So you are able to prosecute them, and the Indian law of passing off is primarily based on the principle of the first adoption. Who adopted first? Honest and bona fide prior adoption means thereby who adopted first means thereby whether you are the first person to bring your product in the market. If you have sold, you have brought your own product, it means you are the real owner. And the person who is a junior one, who is coming later than you, that person is deceiving the market. That person is deceiving the consumers, and that person of the same product, if it is of the same product. If that person is carrying the same trademark, product may be the same, but the trademark having impression that this is the apple, you are also selling the apple, you are also purchasing manufacturing, and the other one is also selling the apple of the same trademark. No, you cannot. Under that particular trademark, one cannot do that. So this deceptive trademark, deceptive similarity is one of the vital tabulation that is sought to be revolved by the Trademark Act. As per the section 2, a mark shall be deemed to be deceptive similar to another mark if it is nearly resembles that other mark as to be likely to deceive or cause confusion in the minds of the consumers. Means it should be very clear, very distinction. It should not cause confusion in the minds of the consumers. Like Colgate or the Colmate, like even the apple, Ulta and Sida, means causing that confusion in the minds. Okay, yes, this is the apple, or this is the product, the Colgate. No, that is leading to the confusion in the minds, maybe in the brand, maybe in the adding label or the trademark, any of the form of the trademark. Maybe this way, even say the apple green and the apple, maybe the green giving the impression okay, this is the green apple because the apple remains green or apple remains red, which is the fruit, apple fruit. So it has not been given the color of the apple fruit. It is not the fruit that. It is not a generic. So generic name cannot be protected. So it is the definitely arbitrary mark. Arbitrarily it has given to the gazette, electronic gazette. Like a McDonald or McDonald. So causing confusion in the minds, yes, M is there, but see the word, one is the McDonald, the other one is McDonald's. You understand it? Or otherwise, nikah means the somewhere the click is very clear, but the upper what is written nikah, and here it is the Nike, or otherwise Puma. So that is okay, somewhere the tiger is hanged there. Tiger is there, but it is hanging. Here it is Puma, under even encircled with the R. So that is what is there. Or otherwise, if you say the mark, again you will find this mark can be even the signature, number mark may be in the name of the numbers, 555. 555, another the song. So that can be it's now the mark. Or otherwise, this rings, 7 rings with a curl combination. So you can understand this mark also. Or otherwise, the packaging even. Packaging that can be even, and again it is falling under the mark. The packaging means how do you package, like a box, container, covering, folder, receptacles, or the vessels, cascades, whatever it is there. Like muesli, you find yes, this is the package of muesli, or other the package of the LED. So the message is clear to the consumers. Okay, the particular product is available there. So like here, it is the case law actually. A simple case law, you will just Benz Mercedes, then Mercedes. Okay, Daimler Benz versus Highbrow Hindustan Airs. There was a case actually under this, and here the case being a Benz and the three pointed Benz is with the three pointed arrows actually, and circled with the this one the ring, which happened to be the surname in the German man. The surname is there actually. The defendant in India, but he started using the undergarments, particularly the underwears, which is considered as ordinary goods, which cannot be associated with the finest engineered car actually. And this gentleman, Daimler, he prosecuted Highbrow Hindustan. Okay, gentlemen, why you are using the Benz logo on your underwears or your the hosieries? You cannot, because Benz is a surname and it is registered, it is associated, it's a well-known trademark by the German, and you cannot just make the people fool. And the court held it that yes, company wrongly had chosen the mark Benz and accepted it, and was asked to stop it, and after stopping whatever the damage caused to the Benz, he was asked to repay the damage. So that was stopped. Even the service marks. So this service mark, like intangible products or supplying the products, supplying the public needs, communication, electricity, then insurance, water, whatever it is. So you feel it, okay, like this is what the mark you will find in underneath here, the McDonald or the service or electricity. Or otherwise the shape mark, you will also find the shape mark. Shape mark, these marks can be categorized as a dress mark, which is also termed as dress mark, like the Coca-Cola. This is the dress mark. Means 3D, with the shape of the 3D mark, which are capable of differentiating the mark existing and the mark which is with the cap. So that way you understand it. The certification mark we have done with the certification of mark. Then you will find the pattern mark. Again, the general meaning of the pattern is the repetition of the similar design. So it's a type of the trademark wherein the pattern is able to distinguish the product and the services of one brand from the another, and difficulty to be distinguished and have high chance of the infringement. So pattern, there are high chances, like a bag, shoes, etc. So they are the pattern. Somewhere bag goal wala aata hai, then pittu aa jata hai. Means there is a different mark. But the repeating this pattern, sometimes it is very risky actually and likely to be infringed. Coming to the other part here, that is we had the conventional and the non-conventional. So conventional mark almost we did. So we are discussing about the other non-conventional mark. Non-conventional mark, which is either the smell mark. So how the smell mark can be identified? Smell mark, because everybody or the cannot just see, but a group of the people, they can smell. Everybody cannot smell, but mass or the majority people, they can smell. Then there is a still tug of war actually whether smell mark can be marked or not, can be registered or not. And that smell mark, because keeping in mind it should have the graphical representation, whether the graphical representation can be there. If yes, then whether it will be having the utility to the people. So therefore, it says in comparison to the sound mark, the color, trademark, and the number of the smell and the scent or olfactory trademark registered are significantly less. One of the reason could be due to the inability of the graphical representation. But the people says yes, it can be graphically represented because it's a composition of the chemicals, composition, and the composition of the chemical that can be graphically representation, A plus B plus C plus D, the composed of the particular product. That can be, and that graphical representation, if it is easy, so that can be considered. Even the European Union, they have this registered trademark. The European Union, as an example of the registered trademark, this US, they have the vanilla scent is there, and or the fragrance, they have this fragrance. They have the registered trademark. Or otherwise, sound mark. Whether the sound mark can be there. Sound mark is registered in India. It is another non-conventional mark, but even similarly, they have realized it can be graphically represented. It can be made. Only those notation of the sounds that are graphically represented can be registered as a trademark. Sound mark being an audio form, or the trademark is challenging, but a figure out the accurate nature of the sound mark is based on the registration. Like you are able to recollect the National Stock Exchange theme song. National Stock Exchange, if somebody has played in the National Stock Exchange share market, so they understand it, they can very well see a theme song is there. Or otherwise, ICICI Bank, they are also having the jingle bell, the mark, they say ding chick, ding chick, ding chick. So that is another, the sound mark is there. You will understand. Or Britannia Industries, the bell sound is there. Or Cisco, Webex, they also have the tune. Okay, when you are switching over to the Webex, so some tune is heard. So they also have this particular sound mark. Or Edgar Rice, bro, they have the Tarzan yell. Or Nokia also have the guitar note. Or otherwise Tata, if you see the Tata Docomo, so something something like that. That mark, that sound, you understand, you realize it. Okay, yes, this is relating to the particular sound. So this way, dear friends, of course, the topic is a little larger. The infringement part, I will just discussing just infringement part actually. Registered trademark, how you can infringe, or how you can prosecute somebody if somebody is infringing the product. So this way, section 27 of the trademark, it provides the legal initiate, and you can prosecute somebody who is infringing the trademark which is registered, because it is your high value work, it is your intellectual property, it is your goodwill, it is your property which is available either in the physical or in the virtual mode. If somebody is stealing or somebody is infringing your product, you have the right to prosecute, because it is causing loss economy to you, it is causing loss to your goodwill, because on the name of your goodwill, somebody is trying to trash or tarnish your image, bringing the product which is deceptive, similar in the market, and causing confusion in the market. So this way. On the other hand, if we are going ahead with the infringement part, one very lovely example of the trademark infringement, you will remember it, Amul won the trademark case in Gujarat High Court. Amul trademark, this was concluded that the utterly butterly delicious Amul name cannot be used by any other proprietor, even if a company is selling the goods other than that sold by the proprietor, who has registered as a trademark. In the significant judgment, the Gujarat High Court has ruled that registered trademark has user has the right to restrict the others not to use the utterly butterly delicious amul. High Court, High Court judgment was in connection with the case where the Kara District Cooperative Milk Producer Union, popularly known as Amul Dairy, and the Gujarat Cooperative Milk Federation had filed the trademark infringement case against the two local shop owners, which was Amul Chasamgar and the Amul Cut Piece. Because this utterly butterly delicious Amul, they were used by Kara District Cooperative, and the other person, they also started using that Amul utterly butterly delicious Amul. So they prosecuted it, and the court held it, okay, no, this is the registered trademark and you cannot use the trademark. They were charged and they were asked to stop using that particular trademark. So this is in the virtual, this is in the physical world, but even in the virtual world, a simple example I'll give you. Here it is talking, we are talking of the trademark in the virtual, in the physical world, but on the this virtual world, we are knowing it as a domain name, because it is not the physical transaction, it is now has taken place the e-commerce or the online gaming or online shopping or online transaction. So when we are switching over to the online transaction or online business or online services, so there we are asking to register the domain, and that domain name is known as the trademark of the proprietor. And that way, because the information technology 2005 has taken it very seriously, and when it was incorporated, enacted, it was not apprehended this will take this situation and we will be totally dependent on it. Like very simple and very well-known cases. One is I'll be just discussing with you. The other is Rediffcom. Yahoo Akash Arora. Yahoo Akash Arora case is there, and Yahoo Akash Arora, Yahoo versus Akash Arora. This Yahoo incorporation, Yahoo.com is a well-known domain actually. When we are using and we are creating our ID on the Yahoo services, this Akash Arora, he started using the YahooIndia.com, and he started okay, Yahoo India is there, and when he started using it, the many consumers, they started YahooIndia.com is one and Yahoo incorporation is the different one. So definitely people are having their own affiliation with the India and having that impression, okay, it is our Indian. Why to go for the Yahoo? Then Yahoo prosecuted Yahoo Akash Arora, the owner, the proprietor of the Yahoo India. Okay, how you can have Yahoo? Because it is very similar, it is causing confusion to the users. And based on that, because the services which is provided by Yahoo is not similar services which is Yahoo India. People, but whoever is registering their ID on Yahoo India, having that impression, okay, yes, every facility, every services that will be similar to the Yahoo, which is not. And ultimately court ordered it, okay, no, you cannot do it, and you have to pay the damage for it. Similar cases, the SBIcard.com and the domain active property. SBIcard.com having impression yes, SBI card is dealing with the particular the SBI cards, whereas the domain active property, they have misled it. SBIcard.com was ordered by WIPO to transfer to the Indian company from the Australian entity. It was grabbed by the Australian entity, and ultimately it was hijacked, and the WIPO asked them ki, no, you cannot, because you don't have any relation with the State Bank. The panel accepted ki SBI Cards Council argument that the Australian company was in the business of buying and selling domain, which is considered as a cyber scatting. The cyber scatting means cyber scatting, okay, you create the domain which is famous in the market, and ultimately when we are switching over to the domain, you cannot recreate of the same. Means similarity will be there, and because of the similarity, it will be denied to you. Then the people, those have created, they will be asking you money. Give me the money. Okay, I'll sell this particular domain because this domain is related to you. So this way, this domain, domain name is considered as infringement, and the cyber scatters, they are in the market of infringing the virtual trade name or the trademark in the, even in the virtual world. Virtual world is also not safe, like the cyber scatting. So this way you may understand that cyber scatter register the domain name containing the variant of the popular type of scatters. They rely in the fact that the internet user will make a typographical error, and you will easily go ahead with the particular the domain. I think I have taken much time. Hello?
Hello, yes, sir.
Yes.
Sir, thank you so much for this informative talk. There are few questions. Would you like to take it?
Yes, I'll go ahead with it, please.
So there is a question by Rajesh Kumar Jha, whether registration of sound trademark, smell trademark and single letter color trademark is acceptable or applicable in India?
Sound trademark is available, smell mark is not yet. Single letter is which is registered before the 1999 Act. It is existing, but now it is not acceptable. It is not registered. I told you, okay, it is then arbitrary work actually. Even the single color one cannot register. Single letter, single number one cannot register. It can be a combination of the letter, combination of the words, alphabets, or color combination. So that can be there actually. But sound mark, it is registered actually, not the smell mark as on date.
Okay, thank you, sir. Sir, one more question. Like you have talked about registered trademark and unregistered trademark. So can anyone use unregistered trademarks or not? Like, what is the difference between these?
Yes, that is what actually the person who is not yet registered with the trademark, and the distinction between the registered trademark, the difference is only that if somebody, your business as a registered trademark, if your business, you are doing your business, you are safe, and you can establish your goodwill. Nobody can harm your business. Nobody can encroach, nobody can infringe your trademark. But on the other hand, when you are unregistered trademark, the proprietor, your business can be taken up by anybody. No, you are not in capacity to prosecute. If anybody is infringing your business under the particular trademark, you say this is my trademark, but your trademark is not registered. It is not protected actually. Okay. So the purpose is who came first. I told you he is safe. Who came first? Who adopted first? If it is you, then you will prevail in the market, and it will be under the impression prior existence, the first owner, and as a first owner you have the right. Because it is known. Because when you are talking of the intellectual creation means who created first intellectually. There are many ideas. If I'm not wrong, if the copyright or the idea copyright, the lecture is over. So if you remember it, then yes, whether the idea can be protected or not protected. Means, and there are many ideas. We are the people. We are working with the many ideas, and if the ideas are there, these ideas, we can carry our ideas, but it is not safe. It is not protected unless the ideas are executed. Similar thing is here actually. Okay, this is the creation of the intellectual people, okay, which can be the catching image, which can be the tagline, which can be the name, which can be the signature, which device can be there to catch the consumers, which can be attractive, which can be more beneficial to the business. So that is what is the intellectual. Means that when we are creating it, when we are bringing our trademark in the market, it means the trademark is open to everybody and it is known to everybody. So this way that can be protected. Otherwise, non-registered, he is not.
Okay, thank you, sir. Sir, there is another question by Zoal Hassan. Does this trademark also be done for the logos or name other than goods and services like NGOs or institutions?
Anybody can have the trademark. It can be even logo also, I told you, device. It can be a name also. Like if you remember, there is a name WhatsApp on the hosieries, sports. So you will find, yes, the hosiery, maybe the t-shirt, maybe the sports hosieries, you will find from the WhatsApp. So that is another name. So I cannot prosecute him because he has taken the name and he is pre-existing. Naturally, his intellect started working there, and that is protected. So nobody can actually claim for it. But band hai, like in Punjab, we have the bands. So having that impression, my bands, it is very similar. So I shall start with the bench, but never know the band was existing in the German. And that is very finest engineered work of the particular vehicle. So we cannot start using that bands.
Okay, sir. The next one is by Sangram Keshri Panda. If someone tried to copy the logo of the owner and started his business, then how to complain and where?
Yes, how to complain? Say, the main problem for the management is there actually. And for the management, the people after starting the business, they hardly people they monitor it. But still, like this gentleman has stated, how to complain? How to complain? Means only the thing is, it is the court of law, the jurisdiction where your jurisdiction is there, in which the particular jurisdiction or locality your court lies. You can prosecute, you can file a complaint. This is my business is harmed by using this particular logo. Then you have to establish. How it is harmed. Whether your trademark, your logo is registered. First of all, you have to certify that I am a registered owner of it. Along with that, and as a registered owner, then how much loss you have caused? Because definitely everyone as a proprietor, as a businessman, then we are maintaining our logbook also, account book also we are maintaining. Then after understanding and after observing, okay, this is the competitor has entered in the market. Now I have started bearing the loss. Why? Because my competitor, and this is deceiving my product. So this way he can prosecute, this way he can prosecute in the particular jurisdiction.
Okay, thank you, sir. Sir, one more by Shraddha Mahindra. Can a
Ji.
trademark having same logo but small change in design or color pattern be registered as another trademark?
Yes, it can be registered. See, section 12 के अंदर there is a provision actually the concurrent user के अंदर भी है, and therein under the section 12 there is a concurrent user. If the both the users in the same business they want to continue, they can continue. First of all, they can exist, provided nobody is harming anybody. Nobody is harming. But on the other hand, if you want to say, okay, no, I have my own personality, I have my own image, and I do not want to continue with this person, and it will definitely harm my business. So the first person who has registered, he will prevail first of all. The second is when you are applying as a second applicant, then depending on the registry, and then depending on the registry of the trademark, it will analyze whether your mark application in the existing mark has any distinction. If it is distinguishable, it can be seen by the user as on the say stepping yourself into the shoes of the user. If you can make analyze, then yes, it is acceptable, otherwise it is not. Because sole purpose, we are accountable to the users, the consumers. Consumers should not be cheated. Ji.
Sir, one more is there by Rajesh Kumar Jha. It has been seen that .org or .edu or the similar kind of CCTLD or GTLD have not been applied by them seriously by many industries, educational institutions. So whether any specific rule is applicable if they fail to take it seriously, like about this websites .org or .edu.
As such, it is not seriously, but still it is the ICANN actually, which is dealing with it. And if the internet assigned domain names, the assigned domain name agency is there, or some disputes of the domain name dispute agency is there. If you have some issues relating to that, but there we can proceed with the complaining. Otherwise, as such, because even if you are not the person who is supposed to create your ID in the org, but fortunately you are from the academic. So then rather than creating your ID in the AC, you are switching over to the org. So as such, there is no problem actually.
Okay, thank you, sir. If anyone from the audience wants to unmute and talk with Professor Watts.
Yes, please.
I think no one. They have already written their questions in chat box. So if there is no one, let's thank our speaker. Thank you so much for giving the time.
Sir, thank you very much. I'm Dr. Preeti Puri. It has been such an informative session and all the practical examples. I think now no one can befool us. When we are traveling somewhere, if someone comes and shows us, we'll definitely, keep all these things in our mind. So thank you very much. You really raised the bar of our short-term course.
Thank you, Preeti. Thank you, sir. And thank you all.
Thank you, sir. Thank you.
Friends, stay healthy. Take care of yourself, please. Thank you.
Thank you, sir. Okay.
God bless.
Thank you. participants, there is a announcement. Tomorrow the session would start at 11:15 instead of 11. So kindly join by 10:30, please.